Okay, I'm going to call to order is this on? Okay. The meeting of, the special board meeting for Friday, December 1st for Santa Barbara School District Board of Education. We're having a special meeting to discuss compliance with new, well, not new, discussion of our existing and proposals for new expulsion processes and policies. And I think a number of us had anticipated a slightly less formal setup for us, where we could engage in a bit more dialogue than is usually allowable at a regular board meeting. So I'm told that Mr. Gonzalez is going to present the information in about 5 or so categories, and we'll see them. Oh, I see what you mean, the ones that are listed here. Okay, so the categories that are listed in our packet. And what I'm inclined to do is to invite public comment under each of those categories, rather than having people just have to give blanket comments at the beginning. So that will give people an opportunity, one, to address more than one part, if you so choose, and also to be a little bit more specific and to hear some of the information before you have a chance to comment. I would like to ask the board's permission to allow a little bit of question and comment beyond what we normally do at regular public input, as we had sort of anticipated this being a bit more of a dialogue with interested parties. So we will try to be a little bit less formal than we normally are, but we will ask people's indulgence to not dominate too much the time that we have. Okay, so with that, I think I will turn this over. Oh, yes, I'm sorry, we haven't officially started our meeting yet. Let's begin with the Pledge of Allegiance.
Please rise.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay. Okay.
Madam Chair, I just have one. Do you want us to fill out a speaker form?
Yes, please, if you do wish to speak to any of these components, would you please fill out a speaker form? And we will just proceed with some announcements, and then we'll get to the body of the meeting. Just want to point out that Mr. Gonzalez will be our Spanish language interpreter at this point. Were you going to, I'm sorry, I wasn't sure if you were going to stay to interpret or not.
I can if I need to, I guess. Hi,
Okay.
my name is Alma, and I'll be doing translation if you need any. I'll be sitting over here.
Y en el
Spanish,
lenguaje.
en español. Mi nombre
Sí.
es Alma, y si necesitan traducción, estoy acá sentadita a un lado.
Gracias, señora. Okay, we also have headsets available for anyone who is hearing impaired and would like to have that technology. Is there any correspondence that board members wish to put forward? Hearing none. I will entertain public comment at this time for any item that is not on the agenda for this afternoon. We will be, as I said, we'll be discussing the district's expulsion process. If you would like to address another item, you can do so at this time. We will be adhering to the 3-minute policy on this one.
Ms. Smith, do you have something that's not on the agenda? Yes. Is that, oh, okay.
This is related to expulsion, though, which is why I'm here. It has to do with the fact that No Child Left Behind has created a very serious problem. Instead of doing what they say it's supposed to do, it turns out that the states are lowering their expectations, lowering their standards so they can meet No Child Left Behind. That's one. 2, teachers will not take challenging classes because there are penalties if the children don't make their AYP, adequate yearly progress. But 3, the most disastrous part is that they are getting rid of the students who are low performing. Expelling students is one of the ways to get rid of kids. But an easier way is to send them into the truancy program. It's great for the schools. They love it. They get rid of the lower performing students, and so their test scores go up. But here's the problem. The students who are low performing are probably learning disabled or have emotional and mental health issues. It is the responsibility of the school district to seek these children, to assess their problems, and to rectify the situation, not to get them into the truancy program and send them to El Puente. Now, I've been to the SARB meetings. The SARB meetings were working without agendas, minutes, or any kind of documentation until I showed up about a year and a half ago. Now, there is no public defense or advocate for the families or students on the SARB. They say there is, but the woman, Isis Castaneda, who they say is the parent representative, is a parent of toddlers, and she works for the truancy program. Now, the reason this is such a conflict of interest and so dastardly is that when you put your students into El Puente, you lose the ADA, so you're losing money. You are failing students that desperately need your help. But Bill Cerrone and the county get twice the ADA that you would get. He gets twice the ADA for these kids. And these kids then become a part of the juvenile justice system. Do you think that's healthy for the kids, especially the ones who are depressed, especially for the ones who have learning disabilities, who can't learn the way they're being taught? They're probably depressed. No wonder they don't want to go to school. I'm begging that you put somebody on the SARB that will help those children.
30 seconds.
Thank you. And that you would pay attention to what you're doing with the expulsion process. Every time you expel a student, you are the failure. In the Mental Health Services Act, which was enacted because mental health was in such a shambles, it was just a big bureaucracy, they are doing what's called wraparound services. That means whatever it takes. I'm begging you to use their strategy of whatever it takes. Thank you very much.
Thank you, Ms. Smith. We do have one more public comment.
Ms. Bernard, it has to be something not on the agenda, so not about expulsions. Is that a?
I'd like to comment on several things, and one is, I don't have a copy of the agenda with me, but this isn't agendized as a public workshop or a workshop. It's just agendized as a special meeting, and I was a little surprised when I saw this on the agenda on a Friday when no one knows about it, at 1:30 when all the parents are at work, why you would have, and you didn't apparently notify the news press, or there was no notice to the parents that this would be coming up. So I'd like to know what sort of meeting this is, or what the intent of this meeting is, and why it's held with no announcements on a Friday in the middle of the day. The other thing is, I hope that you will address the problem of the involuntary transfers when you're discussing this. I also want to to add to the comments that Kate Smith just made about the truancy program and the SARB. You're sending kids as a way, another way of getting rid of them besides expelling them. You're sending them to the truancy program. Some of them are special education students. They're being referred to the truancy program completely outside of the IEP process. That's illegal. And the problem of kids with unidentified disabilities being sent to the truancy program because they're starting to have problems in school since their disabilities haven't been identified. There's no there's no requirement that these kids have some sort of screening to see if there's a disability behind the truancy and the SARB. I've looked at their minutes. They're, because of the advocacy of Kate Smith and other people, they're now having to abide by the Brown Act and actually have minutes and record the results of their closed sessions. And, you know, they don't do anything but refer these kids to the same counseling. They don't identify what counseling centers they're sending them to. But there's no one on the SARB that's from nonprofits except drug and alcohol nonprofits, those nonprofits that already couldn't exist without the schools. They get a lot of money in conjunction with the schools. There's no one on the SARB that clearly knows the range of services available in the community and that can advocate for these kids that might have disabilities that aren't being identified. These kids are funneled straight into the criminal justice system.
Thank you, Ms. Bernard. Okay, that concludes public comment. We can move now to our agenda item, and Dr. Sarvis will introduce Mr. Gonzalez.
Good. This is a review and discussion of the Santa Barbara School District's expulsion due process procedures, expulsion hearing procedures, expulsion appeal procedures, and stipulated agreements. I've asked Michael Gonzalez, who is our Director of Compliance and Categorical Programs, to start by giving the board an overview of these major areas. As the board well knows, but I don't know that everyone else knows, we've had discussions about various issues in these areas for the past year, certainly. So I've asked for him to give a major overview and to describe what we think are the most effective procedures in each of these areas. And those areas, again, are expulsion due process procedures, expulsion hearing procedures, appeal procedures, and stipulated agreements. So with that, Mr. Gonzalez.
Dr. Sarvis, thank you very much. Board members, members of the public, and school administrators, thank you for taking the time to be here. I'm going to begin with a PowerPoint presentation that is going to give you an overview of the expulsion process in our district, and then specifically hit the concerns, the issues that have been brought to our attention under each of those 4 topics, and some recommendations for you to consider. The PowerPoint will end with what staff believes may be consensus among the board based on the 6 previous board meetings that have discussed this topic. With your permission. The first step in the expulsion process is the alleged offense is reported to a site administrator. Second step, the administrator conducts an investigation to find out indeed has there been a violation of the California Education Code section 48900. The third step is the student is suspended and the parent or guardian is notified. Step 4, the school notifies the district of a proposed expulsion. Step 5, there's a discussion that takes place between the school and the district. By and large, it is the designees of the superintendent, which is Jan Zittel, the assistant superintendent, or myself. The kind of issues that are covered before a expulsion recommendation proceeds is what part of Education Code 48900 was violated? Is there admission by the student? Are there adult witnesses to the action? Are there other witnesses? Is there evidence to support the recommendation to expel? Is a student a member of a protected class? In this regard, we're talking about 2 kinds of students. A student who is receiving special education services and a student who has a 504 plan. Are there extenuating circumstances? Step 6, the district notifies the parent in writing of the recommendation to expel. Step 7, a manifestation determination IEP meeting is held for special education and 504 students. And for students in this category, an expulsion proceeding does not proceed if the IEP team does not feel that it is appropriate disciplinary measure. The And it's a majority rule on the recommendation. One of the things that is determined is at the time of the suspension, was a compliant IEP in place? And if a school cannot prove, if the team cannot prove to itself that there was a compliant plan, the disciplinary recommendation does not proceed for expulsion. The administrative hearing panel is held, or a stipulated agreements if attorneys are involved. A hearing is held before the Board of Education in closed session. Step 10, the Board of Education renders its decision. Step 11, the parents are notified of the board's decision. Step 12, the parent or guardian has the right to appeal to the County Board of Education. And 13, upon successful completion of a rehabilitation plan, the student may petition to return to a school. Rarely is a student permitted to return to his home school. It is the practice for our district to send the student to another junior high school, or in some cases, elementary school. I want to share with you the importance of a rehabilitation plan. Part of the expulsion process is about making sure that our schools are safe. It is about giving an appropriate consequence for students who have violated in a serious manner a school rule, but it's also about addressing the behavior that led to the behavior. And a rehabilitation plan can include anything from counseling services in the community. One of the agencies we use frequently is the teen court system. As you know, many of the expulsion recommendations have to do with substance abuse. We regularly use the Daniel Bryant Center as a referral agency for the rehabilitation plan, but there are a number of other resources that are available and are recommended. I am now going to go into the areas where we've been exploring the expulsion process over the last 6 meetings. One of them has to do with the concept of expulsion due process procedure issues. One of the things that board members have expressed a concern, members of the public, has to do with parental notifications. Very clearly, legalese makes letters difficult to understand. Another point, it's been brought to our attention that sometimes parental rights are not fully understood. 3, board currently permits parents to make an oral or written presentation to the board in closed session. And 4, there have been concerns about the lengthy process involved in expulsions. Recommendations to those specific points: continue to minimize legalese. Sometimes it's difficult to do, but it's an ongoing struggle. Highlight parental rights portion of the parent notifications and include legal services that are available in the community. We would have to gather that information. I share with you that the board is advised not to conduct presentations in closed session, and I'll speak to that issue in just a few minutes. And the recommendation is that we implement stipulated agreements to shorten the time, or if we want to shorten the time, we'll need to create another administrative hearing panel. Another topic, area of concern, has been the expulsion hearing procedures issues. It's been raised, who can conduct an expulsion hearing? The board directed that we take a look at that. You may recall that the law requires an impartial administrative hearing panel, a county hearing officer, a state administrative hearing officer, or the Board of Education can conduct hearings. We researched this thoroughly. A report was given to the board about those options. There's also been concerns raised about, is the administrative hearing panel members impartial? Should we permit certificated private school staff as members? And how about the time school administrators are required to devote to the expulsion process? I want to speak briefly to the one of the issues that has confronted the board for some time. There's been conversations about what exactly is a hearing all about? What does the Education Code require? And specifically, we're going to look at a summary of Education Code Section 48918. What exactly are the requirements of a hearing? Well, they include, but they're not limited to, the following. An expulsion hearing must be held within 30 school days. A student can request a postponement of 30 additional days. The board can grant an additional postponement. Within 10 days of the hearing, the board decides. Written notice of the hearing given to the student 10 days prior to the date of hearing includes the date, the place, statement of facts, charges, a copy of the disciplinary rules of the district, a notice of Education Code Section 48915.1 obligation. That has to do with the fact that if a youngster has been expelled, he is obligated to notify a public school system that indeed I was expelled, and the law requires that a hearing be held. We've spoken to the board about that before. But also a notice of the right to appear in person, to be represented by legal counsel or a non-attorney advisor, to inspect and obtain all documents used at the hearing, confront and question all witnesses that testify, question evidence presented, and present oral and documentary evidence and witnesses. Those are the rights of a student at an administrative hearing. Continuing with the requirements of a hearing. The hearing is held in closed session unless a written request to conduct it in a public session is made 5 days in advance. If the board admits any person to a closed session, parent, student, counsel of the student should be allowed to attend the closed session. Special provisions are made for charges of attempted or committing sexual assault. Instead of conducting a hearing, the board may contract with the hearing office, with a hearing officer or an impartial, or set up an impartial administrative panel of 3 or more certificated persons. The hearing panel specifically, the Education Code states specifically, board members and members of the school staff cannot be members of the administrative hearing panel. Within 3 days of the hearing, a determination to expel has to be made. If the decision is not to expel, the student is immediately reinstated and permitted to return to an instructional program, and the rehabilitation plan in consultation with the staff, school staff, district staff, students, teachers, and a student parent is put together. The decision of the board to expel has to be based on substantial evidence relevant to the charges adduced at the expulsion hearing or hearings that the board may request. A disclosure of witness at a hearing can be made in the form of sworn declarations. This is designed to protect students who may be involved in cases of sexual harassment or where there's a very clear indication that testifying at a hearing would result in some physical or psychological harm. We can use sworn declarations. A hearing requires that a recording is made. Technical rules of evidence don't apply, but substantial evidence is required. The board has the right to issue subpoenas. The written notice of the decision to expel includes the notice of the right to appeal, the education alternative placement that's being suggested, recommended, and again, the 48915.1 obligation of parents need to notify another public school district that the youngster was expelled. This section of the Ed Code goes on to say that the records of expulsions shall be a non-privileged, disclosable public record. We've been researching this for the last few days, and we believe that this section of the Ed Code is open to a variety of interpretations, and we do not believe, well, our belief is that it's preempted by FERPA that would not permit a release of these records. The issue here, however, is what is the definition of records of expulsion, and that's not one that we're going to solve this afternoon. Going on, an expulsion order and the causes shall be recorded in the student's mandatory interim record and forwarded to any school in which the student subsequently enrolls upon receipt of a request for those records. Recommendations in this section: that the administrative hearing panel continue to hear the expulsion cases, that we continue the practice of removing from the panel any administrator who, because of a prior association with the student, cannot render a fair and impartial judgment. We do that regularly. I'm also recommending that we limit membership on the administrative hearing panels to public school administrators. And at the present time, we have limited the panels to retired administrators and to assistant principals. We have removed principals from the duty of sitting as a member of the administrative hearing panel. All right, there's been concerns about the expulsion appeal procedures. And the question is there an appeal process for expelled students? And yes, there is. The Ed Code very clearly spells out, Section 48919 outlines the appeal process. Essentially, it says that a parent has a right to appeal, the student has a right to appeal a expulsion decision to the County Board of Education within 30 days, and parents are informed of that right. Stipulated agreement issues. We've also brought this to the attention of the board. The concerns have been that parents may not fully understand the consequences of a stipulated agreement, especially the waiving of the rights. Well, what are these rights that are being waived in a stipulated agreement? Well, it's the right to appear and contest the allegations before the administrative hearing panel and the Board of Education, and also waives the right to appeal the expulsion order to the County Board of Education. But I should have prefaced this by saying that stipulated agreements are only entered when it's very, very clear and the parent-student admits that indeed they did commit the act that, that resulted in the expulsion recommendation. The recommendations continue to be that staff be permitted to offer stipulated agreements, and that, of course, we do not prevent parents from legal representation for these agreements. Up to now, we have entered in a great number of stipulated agreements, and they have been between our attorneys for the districts and attorneys for the students being recommended for expulsion. Our attorneys have very clearly indicated that they believe that we have built enough of an experience base that we can proceed without them. Board consensus. What does staff believe, based on the 6 conversations before the board, that there may be consensus on? It's very clear, I believe it's clear that the board has requested that parents need to be notified of legal assistance. I don't mean by that just that they have a right, but what are the legal resources available? And by and large, we're talking about pro bono. It's, anyway. That parents should be, that students who are in the expulsion process should be in an instructional setting, and I'm happy to report to you that I think we've had one student this year who we've been unable to make contact with them, but other than that, every student is involved in an instructional setting until the board makes its final decision. I believe that we hear that the board would like parents to have the ability to request a hearing with the board. And I believe we've heard that the board wants to decide if the hearing will be held. Finally, we believe that we hear that the board would like school officials present at that hearing if it's going to be held. That, I believe, concludes the slides. I will share with you that this afternoon we have Mr. Bursick, who's an attorney with Liebert Cassidy and Whitmore. He's got 2 obligations going on at the same time, and I suggested to the superintendent and to Bruce that perhaps it would be appropriate if the board has any specific questions about issues of law, that this would be an appropriate time to ask Mr. Bursick. I'm told that he may be able to spend up till about 2:30, 2:40 with us, and then he's got another obligation at another site. I will make other points as we go along, but I think that's enough for now.
Okay, well, do board members want to question the attorney? Okay.
Mr. Bursick, can you provide us with any examples from other districts about providing parents with information about available legal counsel in the community when their students faced with this problem?
I would say, actually, no. I would say the typical situation is the district, as your district does, lets the parents know that they have a right to legal assistance, but most districts do not provide indications of where the person can go. And one of the reasons why they do that is they're concerned about being perceived as involving themselves unnecessarily in the process of who the person is selected. So when it comes up, what usually school administrators do is indicate that individuals should contact the local bar association or legal aid society and the like. But generally speaking, school districts do not get involved in suggesting attorneys or law firms or other places to go.
Can I piggyback on that? Because that brings up the question I was going to ask you, which was, if we were to provide a list of possible resources for parents, would that be construed as endorsing those particular agencies?
Well, I think you could.
Would we have liability if the agency did not provide appropriate counsel to the parents?
Where you could probably get in trouble is if you were recommending specific individuals. If you kept it pretty broad in terms of please contact the local bar association or the legal aid society and ask them, they may have resources. I think that would probably be fine. I think where you get in trouble is if you start suggesting individuals, it doesn't work out with that individual, then you become part of the problem if the parent or guardian becomes dissatisfied with the legal assistance he or she has received.
Are there other questions for the attorney? Okay. If I had one additional question. Okay. We have been sort of around the issue of whether we are required by law or by ed code to have both parties present when we hold a hearing with the board. And so separate from the issue of whether we think it's a good idea, whether we would want to do it or not, et cetera, would you say that we are required by law to do it or by ed code to do it?
I would say, looking at your existing procedure, I would say it's lawful, so that you have a right to hear from one side. But I think that the bigger question is whether it's wise to do that, whether it's fair to do that. And any time that you allow only one side or the other an opportunity to have the proverbial second bite of the apple, it creates an image, or at least the potential, of unfairness. But in terms of strict legal terms, it's what you're doing now is lawful. Where you'd get into more of a gray area is also if, depending on what you're doing in the course of that second hearing, you could also create problems for yourself. Generally speaking, school districts that allow parents and others to attend a board meeting and speak at a board meeting after a hearing panel generally consider it more like an appellate hearing, like you'd have a court of appeal where the parties would be able to argue on the facts, but not bring in new facts. If you get a situation where you have new facts being presented by one side, the other side is not there, then of course that's unfair. And as soon as you start allowing any situation where new facts are being presented or new evidence is being presented, then you have a situation of, are you complying with the requirements of the Education Code, and particularly 48918, in terms of a hearing process that's consistent with the process that's set forth in that provision.
Okay, thank you.
Sure.
Dr. Noel?
Yes. We've had two contrasting descriptions of what the supplemental hearing would be like from a legal point of view. One seems to conjure up imagery of something approaching a formal appellate process, or if we're having, as you say, one side come in and the other come in, as you just advised, what are the rules of procedure? And then on the other hand, we've had a description that that it could be far less structured. And I know on one occasion it seemed to be so formidable that it was, at least from my perception, something that I would try to avoid, because it would be essentially like a trial. We're not equipped to sit as judges in a trial and make rulings on evidence and procedures and so on. But could you, if that's a good question, could you clarify?
Well, it is a very good question. It probably goes to the core of why you're here today, which is what is the most effective way in which you can process expulsions. And there's a reason why school districts utilize administrative bodies, whether it be through the Office of Administrative Hearings or the hearing panel that you use currently, and that is to allow a school board to utilize the expertise that's developed by the administrative hearing bodies. And you have the benefit of the time and resources that is needed, the expertise that is needed in terms of presentation of evidence and ruling on evidence and subpoenas and like, that you have a core group that handles that, and therefore it allows the school board to essentially review the matter, review the records, so to speak, analyze the facts, listen to the written arguments that have been presented earlier, or the transcript that have been presented, and make your decision based on that. So generally speaking, school districts that utilize that system are doing it for purposes of efficiency. Obviously, a school board does have a right to conduct its own hearings, and many school boards do that. But as you've indicated, Dr. Noel, with that comes the responsibility that you have to make sure that you are compliant with all of the rules and procedures that are set forth in the code. So that's why many school district boards do not want to do that, because it is time-consuming, takes away your resources, you don't have necessarily the expertise to do those kinds of things. And so oftentimes it's more of a value judgment than any type of legal determination.
Well, the other aspect of those hearings, I was struck by, you make it sound like an appellate process, that the board is not going to sit in judgment on the facts. Right? It's going to take the facts as given because they were produced in the trial, or at the trial level, meaning the hearing panel level. The most compelling thing, at least for me, in the expulsion hearings usually is not that when the parents come in or the student come in, they introduce new facts. It's the emotion, and especially that goes to the point of whether somebody's going to be there representing the district or the site, because we sit and it's pretty poignant stuff, as you I'm sure know, to hear the affective content of an argument, one side particularly.
I'm not sure what the particular question was, but you're right. That is oftentimes an important component to any type of hearing. That's also the responsibility of an administrative hearing panel to listen to each of those arguments that is presented, in terms of not only the parent or guardian or advocate making the presentation in terms of the consequences of expulsion on that particular student, but also from the other standpoint, the school or the so-called victims, what impact a non-expulsion would have on that. But if you as a school board, and apparently based on this consensus that you've talked about, or at least potential consensus, if you want to be the ones to sort of listen to that, as I said, that's your legal right to do that. But you do have, as you've stated at the outset, your obligation, though, is to base your decision on the record. And so unless you base your decision on the evidence that's been presented, rather than the emotions, then as long as you base your decisions on the evidence that's been presented, then you'll be fine. If you base it on emotions, that's where you can get into trouble.
Yeah. Ms.
Ms. Rodriguez?
Yeah.
Oh, I'm sorry. Ms. Harder?
Go ahead.
Okay.
I have a question about stipulated agreements, which is something that we've been looking at. We've used a few times in the past, and we're looking at moving more in that direction. One of my questions is that more of the standard approach of other districts? And I
Yes.
have another part to that, okay.
Yes,
So-
it is. Pretty common.
And I don't know if you've had a chance to review some of the prior discussion we've had on this, but maybe if you could tell us just briefly, in your legal opinion, what the pros and cons of using the stipulated agreements are, sort of also based on some of the things we've discussed in the past from the slide presentation.
Are you talking about the pros and cons from a school district standpoint or everybody's
general.
standpoint? In
From
general, okay.
everybody's.
Well, certainly an advantage of a stipulated judgment, usually a stipulated expulsion, if we're talking about an expulsion rather than a stipulated suspension. A stipulation suggests that there really is no reason to go forward with the hearing, that the parties both recognize that the facts are pretty clear, and it really is a question of what the consequence will be. And the parties are able, in relatively efficient fashion, to agree upon what the particular remedy will be, or in this case, the rehabilitation process and what other educational components there'll be. So certainly the advantage of any type of stipulations is that is very efficient, and it's usually done where there is really no contention as to what the facts are. It's really a question of, okay, I did wrong, I realize I did wrong, how do we go from here? And so rather than go through a relatively laborious process of having the hearing and the student having to go through a hearing process and the anxiety and tension of the hearing process, perhaps having witnesses do the same, and they're always very tense about that as well, you avoid that situation. The disadvantage, as Michael had indicated, certainly from a process standpoint, is that it's important for the student and his or her parent or guardian to recognize that any stipulation is tantamount to like an admission, and it is in fact an agreement for the person to be expelled, and so that person is waiving important rights, what are called due process rights, the rights to appeal, the right to present and confront witnesses and the like. The person is in essence waiving that right. The person is waiving a right to appeal an ultimate judgment, and is basically agreeing to be bound by conditions of an agreement. So that would be the disadvantage, and it's not a particularly onerous disadvantage, because if so long as the parties enter into the stipulated agreement, knowing what the consequences are, and I think your administrators are well trained in terms of discussing that, but so long as both sides understand what the agreement means and what the consequences are and what the due process waiver means, I think you can avoid those situations.
Yeah, I think you've just hit on what is probably the biggest concern that people have, is trusting the system to be sure that people are properly notified, and not only that they're properly notified, but they understand the system, and I think that puts a lot of responsibility on the district.
Well, there can be handled in one of two ways. Certainly one can be, certainly it's discussed orally, but another thing to do is to include in the stipulation an actual statement that indicates to the individual what he or she is waiving. And so there won't be any misunderstanding. And certainly what I suggest to our clients is, if there's there's no reason why a parent or guardian has to make a decision immediately. If the parent wants to discuss that overnight with his or her spouse, or wants to discuss it with an attorney, by all means that person should be entitled to do that. So it's not as a school district, it should not be your role to try to see how many cases you can knock out and get stipulated judgments. It's really focused on, does it make sense under these particular facts when everyone knows what the consequences of agreement mean?
Thank you.
So that it makes sense without the person having legal counsel, that the parent doesn't necessarily. Is there any way, does it make sense to do it such that the parent has to have legal counsel to have a stipulated agreement, or does that not make sense?
Well, the question as to whether to utilize legal counsel should be left to the decision of the parent or guardian. It's that person's choice. I think what you should do as an institution is to let that person know that he or she has a right to refer and to seek counsel from an attorney. But if that person wants to handle the case him or herself, I think that's fine. I don't say you have to have legal counsel. And very often, I think, as Michael indicated, many expulsion cases, including stipulations, are done without attorneys.
Have you seen any districts where there's something like an ombudsman in the loop?
In terms of the stipulated judgments, you mean?
Yeah, particularly that. I just, anytime you talk about waiving a right of appeal, I choke really quickly, and especially if it's done without counsel. And yet I understand structurally it would be very hard for us, and in two senses, to be objective enough to offer an alternative view, and also to provide or to provide a right to counsel. It's beyond our means. But administratively, I mean, there's kind of a structural bias here. The beauty of stipulated agreement is it's more efficient. It saves us time. That has nothing to do, and that may or may not be relevant to the parent's consideration. And that's where I have trouble with how do you get some balance on that scale? Here we have all the expertise, and at least the people we see often see in expulsion hearings have very little expertise and many of them very little savvy in dealing with bureaucracies and people in suits. And finding some way to get some balance in that is where I've been pretty troubled and struggling. I've always liked the idea of some kind of a neutral person. Now, maybe by definition, if the person's on our payroll, it can't be neutral. Mm-hmm. And I don't know, I just wondered, have you found any models out there that have successfully dealt with these issues?
Unfortunately, no. It's not to say that it wouldn't make sense in certain situations, but I suspect that because of the limited resources and the time that this whole process involves, I'm not familiar with any districts that utilize ombudsman. I think the idea, though, of full and complete sharing of information is one that certainly the district can strive for, and whether it be by through thorough discussions and or having some things in writing, so that sort of gives the parent or guardian an understanding of what he or she is faced with, is certainly something that districts do utilize.
It seems to me that when we're talking about, or at least my understanding of when we're talking about stipulated agreement, the situations in which a stipulated agreement would occur is, let's say, I'm a parent, my child commits some sort of transgression. The school says, we're going to recommend that your child be expelled because we think he got into a fight. Okay, and this is the second fight he's been in this year. I say, my student says, yes, I did it. I say, yes, he did it. I say, I agree, okay, it's reasonable that he be expelled for a semester. The district says, okay, we'll agree to that. He'll be expelled for a semester. And that's our stipulated agreement. And so for me to waive my right of appeal doesn't really seem particularly significant, since I'm agreeing that I'm not going to appeal. I mean, basically, I'm not going to appeal this because I'm agreeing to it. I'm saying, I think it's an appropriate punishment. You think it's an appropriate punishment. The student maybe doesn't like it, but admits that it's the consequence, and that's the situation. So would there be stipulated agreements where the parents were not in? I mean, we wouldn't have one if the parents were not in agreement of the facts or of the consequences, right?
Correct. I think the essence of a stipulated agreement is where the parties agree.
Everybody agrees.
Correct.
So, I mean, making sure that the parents understand what the punishment is seems, to me, the important part. Not so much that they understand the rights that they're waiving, because I don't want to appeal it if I'm agreeing to what it is. So I think my concern is more at the level of making sure that parents understand what the punishment is going to be and what the consequences of that punishment are going to be, whether it's going to require the student to move to another school, whether it's going to require the student to participate in a series of counseling sessions, whether it's going to require the student to be out of the district for a certain period of time. That I'm much more concerned with making sure parents understand that part of it. Because I think the other part, if they agree to that part, then the other part isn't necessary. They don't want it.
Yes, absolutely, I agree with you. that has to be a part of any discussion about a stipulated agreement. I think my understanding of the concerns about stipulated agreements, and maybe I misunderstood, the concern is that there's too much of a discussion about, here are the consequences, you're agreeing to the expulsion, this is what an expulsion is, and not enough discussion about, well, you don't have to agree to this. There are alternatives. You have a right to go to a hearing. So usually from a process standpoint or a due process standpoint, the concern is more in the area of, okay, there is an alternative. I don't have to agree. I'm not given this one choice. I can sign here, and that's what's going to happen because they've already decided it. So what I think is important whenever you agree to stipulated agreements is to make sure that everyone understands that that there are alternatives to simply going through an expulsion. You do have a right to contest this. If you think the facts are incorrect, or you think the consequences of the expulsion or whatever the rehabilitation program is unfair, you have a right to go through a hearing process and test that. And so that's really what sort of the critical aspect of agreements on stipulated agreements are, not so much the idea of what the actual expulsion is. But certainly the idea of expulsion is a necessary component to a stipulated agreement.
Are you talking about a stipulated agreement after the administrative hearing panel or before?
Well, generally, stipulated agreements occur prior to that. So, in other words, it avoids the reason for the hearing. There's nothing to say legally that there couldn't be a stipulated agreement after the hearing panel makes a recommendation. But generally speaking, they occur before the hearing.
See, one of the things that if you had counsel, if the person had counsel, one of the kinds of information counsel will give that, or could give, that I would think administrators would be less likely to, is what are the odds of beating this? What are the odds of going in there? I mean, you've got a couple of points to argue here. Go before the panel, make your case, and make this argument. You have a chance of winning, or even with an adverse judgment by the panel. What's this board like? Is it worth your trouble to go to the board? Maybe given the particulars of the case, you say, this board never expels kids who've done this. Maybe that's not us, of course, that's some other board. But in other words, an assessment. That kind of information I don't see coming out of, short of doing, as you say, referring them to somebody.
Yes, one can obtain all that information from an attorney, but I think the other component is, first of all, with respect to attorneys, unfortunately, we do have a habit of charging for our services, and so many people find it's too expensive and the nature of the case is not worth it. The other thing I think you'll find, my experience has been most attorneys who represent students really don't have expertise in education law. They don't really handle a lot of student expulsions, and very often they're just as uninformed about the rules as a parent would be. So my suggestion, and I think certainly this is the way I'm familiar with most districts, is to make sure that a parent understands that he or she has a right to ask those type of questions. And very often someone in the role of Michael or Jan would be in the position of saying, giving that type of information. And while he is talking about the hearing process, talking about things such as alternatives, such as how often things are overturned. If a parent wants to know how often does it result in someone not being expelled, that's the kind of information an administrator would have to provide the person.
Or not being sent to El Puente, or the kinds of the array get routinely from parents. Okay, but don't do this.
Mm-hmm. Now, I certainly don't want to sell my brethren as attorneys short. I mean, certainly an attorney knows the type of questions to ask, but I think educated parents are also very capable of asking those type of questions as well. And I think it's an obligation for the district administrators to answer those questions.
Yeah, I just want to take advantage of Mr. Bursick before he has to go. In districts that have the administrative hearing but no supplemental hearing by the board, tell me how the process proceeds after that administrative hearing.
Basically what happens after the hearing panel makes its findings, it's in essence going to make a recommendation in writing to you. You would then review that recommendation, review the evidence upon which that recommendation is made, You'd be meeting in closed session, you deliberate in closed session, and then once you decide on what you're going to do, you'd go into open session and formally make your decision.
Okay. And then do boards have the opportunity to reconvene the parties in a supplemental hearing?
Yes, I mean, that's one of the reasons sometimes it does occur where you read the recommendations, you read through the facts or the evidence, and you are concerned that perhaps there are areas that were uncovered, there are questions that you feel are significant that were not addressed. That would be certainly an opportune time to say, we think this matter needs a supplemental hearing, and then you would notify the parties that you would like further information on the case.
Okay. And you would suggest that if there was such a supplemental hearing, that both the school would be represented as well as the student and the student's family?
Yes.
Okay. Thank you.
Are there any additional questions? No? Thank you very much. We appreciate your having your time.
There's a member
Oh, I'm
of the
sorry.
public who's
I
interested.
apologize. We have members in the audience who would like to ask a question of our attorney.
I'd just like some.
Can you come to the
need to come to the
microphone?
microphone and
Since-
tell us who you are.
My name is John Greer. I'm one of those attorneys that he was speaking about. I also am an advisor to the Santa Barbara Teen Legal Clinic, and I'm also the past chair of the Juvenile Justice Delinquency Prevention Commission. I'm currently a member. I just want some clarification when you were talking about who the school district could refer a parent to in terms of a legal entity. We do have the Teen Legal Clinic, which is a nonprofit organization in this community. We also have a legal resource center, and we also have, as Dr. Gonzalez said, entities such as teen court, boys and girls clubs, things like that. Would there, in your conclusion as to not representing, or asking specific attorneys be named, would you have any objection to those kinds of referrals from the school district?
Well, I'm not sure what you meant by the Boys and Girls Club, but certainly the first three institutions you named would be appropriate in my mind.
Okay. The other question I had was when you were talking about the new evidence or facts coming before the school board. One thing that I noticed, and maybe I need some clarification on this, but the school board, as I understand the current policy, has the ability to actually set aside for, I believe, a year, the expulsion recommendation of the administrative hearing panel. And frequently when those appeals are made, at least the ones I've attended at the school board hearing, are more along the line of what Dr. Knoll said, in terms of, we would like that to occur, not necessarily the facts are the facts, but we would like that to occur, and you're the entity that has the ability to do that, or, we don't want to go to El Puente, those kinds of things. Would you consider those to be new facts in that kind of a hearing? And I certainly have no problem with a supplemental hearing having both sides represented, but I was just some clarification.
No, if you're referring to comments made at a board hearing saying I'd rather do X than Y, or I'd like, instead of being expelled, I'd at least like you to entertain the option of a suspension of the expulsion order. Those things are certainly appropriate. Those are decisions that the board can make. And just to make sure that you understand the difference, the board can decide, one, that expulsion is not appropriate. The board can also decide that expulsion is appropriate, but they feel that under the circumstances, a suspension of that order is also appropriate. And they can do either one of those things if they so desire. So if you were the advocate and you were making a presentation, you believe that your client had acted inappropriately and deserved a significant penalty, so to speak, there's nothing wrong with an advocate advocating that a student, instead of being expelled, have that expulsion suspended for a designated amount of time, and then nothing to prevent you from asking that the matter be revisited for readmission and possible expungement of the record after a designated time as well.
But the administrative hearing panel does not have that authority. Is that my understanding? Only the board has
The only authority that the hearing panel has is to make a recommendation as to whether expulsion is appropriate. The board has the decision-making authority.
Correct. And then my last question referred to, the discussion about stipulated agreements. And I just wanted to note that and ask whether or not you would concur that the issue really is, I believe, is making sure that, one, there's not a coercive situation when the stipulated agreement is being made. And by coercive doesn't mean that, somebody's but if you're in a room and somebody, as was pointed out earlier, is in a suit and a tie and you're not used to that or something like that, could be a situation where somebody is not feeling comfortable even though the information is being given to them. And so I was curious as to, even in real estate contracts today, they have in very, very bold print that, whatever you're being told here, you really ought to take these documents and seek out legal assistance. And if we're clarifying that there are places in the community people could go, wouldn't that be a good idea?
Well, it's certainly legal to do that. Generally speaking, because of the nature of the expulsion process and because it's, unfortunately, it happens relatively frequently, and the informality of the whole student discipline process, it generally does not occur. Generally what happens is that administrators will say, why don't you think about this? Why don't you perhaps, if you feel the need, contact an attorney or talk to your spouse or what have you. If the district wants to put in a provision on the agreement saying that the individual had an opportunity to visit an attorney, that's certainly appropriate. That's something that I put in as an attorney to do that. I'm just, those are usually more sophisticated documents, but sometimes that in itself scares parties when you start adding the so-called legalese. But certainly you could do that. One could do that.
Thank you.
I also had a couple of questions. Just building on what Mr. Greer was just saying, and the concern expressed about waiving the right to appeal with the stipulated agreements. In a way, what you're, in waiving the right of appeal, what you're waiving is the right to change your mind later. So it doesn't seem necessary that the person signing a stipulated agreement has to waive their right to change their mind later. And I think in the stipulated agreements that it should say that you still, you have a period of however long to appeal this, because the issue with stipulated agreements is the expulsion process happens really fast, and it hits the parents and the families who are all working. It hits them suddenly, and there's short timelines involved, and they have to decide whether they're going to sign that or not right away. And that's where the sort of overreaching may happen, where they have so much pressure on them that they might sign the agreement and then, after thinking about it, realize, well, why did I do that? I should have not. But there's no provision, since they waived their right of appeal, to change their mind. And so I think that if stipulated agreements are going to be used, that they should not waive the right of appeal. There's no reason to waive the right of appeal. A lot of reason to keep it in.
Mm-hmm. Well, I assume that's a statement of opinion, and certainly it's up to the board to decide whether that's how they want to approach things. What I would say to you is that, first of all, that's generally not done. In fact, I'm not aware of anyone permitting that. Secondly, the reason why sometimes districts enter into stipulated agreements is that they're getting a benefit of not going through the hearing process. Sometimes they make concessions in order to get an agreement. And if someone can simply decide a week later that, I really want to go through with this, then they don't get the benefit of that. But what you're proposing is certainly legal. One could create a situation where someone has a designated amount of time to change his mind. Just not the typical situation. Usually what happens, as I described, is before you sign this, make sure you understand that agreeing, take some time, call me tomorrow or sleep over the weekend on it, and call me on Monday with that, because you recognize that by agreeing to this, certain consequences occur.
Even when you buy a car, you get 10 days to decide you don't like it. I mean, I think the situation like that,
Mm-hmm.
that
Yeah,
it's really
I wish
not
that
going
were
to put
true,
the
but
school at
unfortunately
much
it's
of
not.
a disadvantage to it's gonna, I really don't think it's gonna put the school at that much of a disadvantage, considering the circumstances that the family's being asked to sign these stipulated agreements to allow a certain period of time for them to decide that they don't want to do it after all.
In the interest of time, because I think you're making an argument that's really directed at the board. Mr. Bursick is not going to make the decision about whether or not to include this language in the.
Okay, then I'll go on
new
to my next
policy.
question. That is that,
I just wanna-
despite
I'm
what
sorry,
Mr.
let me just-
Gonzalez,
I'm sorry, just let me interrupt you for 1 second. Do you, what is your timeline like at this point?
I am supposed to be back at City College at 3.
Okay,
So maybe
so-
5 more minutes.
Okay, thank you.
too bad.
Huh? I'll have to walk to the parking lot, though. I didn't park here. I parked. Never mind. We don't want to hear where I was.
Despite what Mr. Gonzalez was presenting earlier, it's not that there's too much legalese in the information that's given to the parents about the expulsion. It's that they often are not given the information about what the student is being, the reason the student's being expelled, the incident that's behind the expulsion, and all the evidence that the district has that they're using to decide that the student should be expelled. That's the complaint that was made, and that's the thing that I've seen a lot. I'd like to take this opportunity to have you tell the board and the administration here what information is supposed to be given to the family when they're notified that their student is being recommended for an expulsion.
Well, as Dr. Gonzalez outlined in his PowerPoint, not usually, by law, the administration is supposed to both tell the student and make an effort to contact the parent and explain what the nature of the recommendation is and the reasons for that recommendation. So there shouldn't be any situation in which the parent or the student doesn't understand why he or she is being either suspended or expelled. Now,
I'm sorry, isn't there a requirement that the parents are supposed to be given the evidence that they have against the student? Notified of what the evidence is?
If you're talking
against
about
the
like
student?
from a legal standpoint of presenting all your evidence in advance, no.
No, when the school first notifies the family of the student's recommendation, for expulsion, that they're then supposed to let the parents know of what the evidence is that supports their recommendation for expulsion. The parent has a right to that.
Well, I don't want to parse particular legal terms. The evidence refers to information that's presented at, say, at a hearing. What I think there is an obligation is for the administration to inform, as I said, to inform the person what is being recommended and why it's being recommended. Generally speaking, that's going to include reasons and the evidence and so on, like he admitted that he brought drugs to school, that kind of thing. But in terms of saying, well, we've got these 3 witnesses, and these 3 witnesses are going to say this, 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 and this, that doesn't necessarily have to occur.
So I'm just talking about generally the evidence, not in
Yeah,
a-
generally, I'm assuming, and one of the administrators can correct me if I'm wrong, but I'm assuming they do tell the parent and the student as to why the person was being recommended for expulsion and what the nature of the
So that's not
reason
supposed
is.
to be in the writing that they receive, the recommendation for expulsion. They're not supposed to be given the reasons in writing why their student's being expelled.
Yes, it should be in writing. There's usually a form that's used that will indicate that. So if it's possession of drugs, that'll be indicated. If it's brandishing a knife, that will be indicated.
Well,
If it's disrupting a classroom, that will be indicated.
I'm not just saying that they're supposed to have like a little phrase that says why they're being expelled, but a written explanation of why they're being expelled.
Again, I'm somewhat at a disadvantage because I haven't seen the particular cases that you're referring to in Santa Barbara, but what I can tell you in other districts is those kind of comments are included generally in the recommendation. Now, it's not an exhaustive discussion about all the evidence,
Right.
but it is sufficient to let the student and his parents know why it is that the person is being recommended for
Okay.
expulsion.
And that's what I'm saying isn't being given to the parents. The information, they then end up at this hearing without knowing, what the evidence is. that the
Perhaps your
district
question may
has.
be better addressed to one of the administrators. or
Number one, I think we
Dr.
would disagree
Summers.
with that, but more importantly, I think that would be something that would be directed at the board and doesn't need to take your time when you need to be at another at another meeting. So I'm going to allow you to take your leave now and continue with your additional appointments. And I appreciate your being here to explain the elements that we needed some help with.
I have
Thank
one
you.
more question. He doesn't need to leave till 3.
No, he needs
His
to be at
appointment's at
Santa Barbara
3.
City College at 3 o'clock.
Oh, I see. Okay. In that case.
Thank you.
Okay, Mr. Gonzalez, had you concluded your presentation? Did you want us to take input, comments and have discussion now?
I was going to share with the board and with the members of the public a couple of things that I think should be understood. We invited Mr. Fred Russo from the County Board of Education to be present. He wasn't able to be here, but we've had a number of conversations with him. As you know, and it's been reported in the news press and has been reported to you folks, I indicated to you that we had 105 recommendations to expel last year. And as the compliance officer in charge of that program, I lamented and carried the burden of 105 recommendations. I think that's a large number. I previously shared with the board that at a conference of colleagues with my responsibility, there are some districts in Los Angeles, secondary districts our size, that were reporting 25 expulsions per year. Those 25, what they've done is they have stopped expelling students for second and third violations of drugs. They do not proceed with recommendations for carrying knives. But I want to stop here and share with you, I will not name the districts, but 2 districts north of us. It has come to our attention that 2 districts north of us, high school districts, have regularly between 20 to 24 expulsions at every board meeting. About 20 of those expulsions are suspended expulsions that result in the students being sent to that district's continuation programs, and 2 are sent to the El Puente equivalent of North. In another district, the first-time drug violator is expelled. I've shared with the board and I've shared with the colleagues before us that I do think it is time to retake a look at our discipline policies. I've shared with you, I've shared with members of the audience that I'm not altogether certain it is now effective or appropriate to expel youngsters on a second drug violation. I would rather see a more intensive intervention, and if we get to the third point, I think it's an appropriate measure to take. The other point that I want to clarify is it's easy. First of all, I want to admit to you how difficult it is for parents whose youngsters are being recommended for expulsion to deal with the process. It is a shocking, gut-wrenching kind of environment for families to try to wade through. But I want to assure members of our board and members of the audience that every effort is made to make sure that parents understand every step of the way what's going to happen. And those steps begin at the school sites. There's not a youngster who's recommended for expulsion who hasn't sat down, by and large with assistant principals, though sometimes it is with principals, and very clearly understand why they are being recommended for expulsion. The stipulated agreements that the district has entered that you have approved are never signed, here's the paper, sign. There's always at least a week, if not more time, before stipulated agreements are signed and submitted. There is no such thing as let's do it right now because we're under the gun. It is a process that does require thoughtful thinking. I will admit to you that we have not taken the step of including in our letters You may consult with as a legal resource. We're awaiting your direction to do that. But I want to make sure, I want to reassure members of the board that you should not have doubts that the folks sitting in front of you and district staff, that we do exercise great judgment, fairness, impartiality, concern for parents and students throughout this process. The last comment I want to make to you is that I very clearly believe that expulsions are about keeping our schools safe. And I make no apologies to anyone for that. Second of all, however, it is about consequences for behavior. But third of all, and that's where I began the conversation, it's also about addressing the behavior that led to it. I've shared with the board, and I'm not altogether certain that I've shared it as openly with our administrative staff, but the number of youngsters who go through an expulsion process and come back a second time are negligible. I think in 3 years worth of data, we've had one youngster. And so the rehabilitation plans that the administrative hearing panel recommends, that often are made up of members of our administrative staff sitting beyond, work and work very effectively. Thank you.
Mr. Gonzalez. Okay, Ms. Rodriguez. I was just going to say we have members who wanted to speak, but we'll take the board comment first.
Just a quick question. We have lots of administrators here and members of some of the organizations that serve our students. I just wanted to ask the process whereby we would be able to take their input and their concerns that they might have about the process and give us some feedback. Are we just going to see who wants to speak, or how did you want to handle that?
Well, I think several of our administrators have submitted forms to speak. Is that correct? Am I correct on that?
A few.
Okay, a few. Yeah, we would like to hear from more of you, actually. But I think that was the intent of certainly anyone, members of the district or public, can submit to us in writing any information that they want. Did you have an alternative suggestion?
I just have some questions. I'd be interested in feedback from the staff at some point. So, and I'm sure other board members do too.
You would like to hear from them, from their point of view. Absolutely.
I think that we can ask questions of people who are present if we would like to.
So true. May I suggest, we had anticipated that in the process that we would take each of the four major areas. I know we've been talking about stipulated agreements, but we would take each of the four major areas, have discussion about those areas, invite comments about those, then move on to the next area.
Yes. So that would have us starting with the area of expulsion and due process procedures. The actual procedures and process by which the students are expelled, in terms of parental notification, the hearing panel's recommendation, etc. So, I guess what I'd like to do is invite comments on that area of the discussion to begin with. So, we have members. If you want to speak to this, you can come forward and speak. If you haven't submitted a speaker slip, but you want to speak to this area, you can come forward as well.
I don't mean to interrupt you.
It's
I'm
okay.
sorry. May I also say that we have copies of the PowerPoint. They are available on the side table. At the end of the PowerPoint, you will have recommendations that are attached to each of these four areas. So the first set of recommendations has to do with the expulsion due process procedures. The next set of recommendations has to do with the expulsion hearing procedures and so forth.
Could you reiterate exactly how you're going to proceed this?
Yeah, I agree. I think it's a bit confusing. But what we had anticipated, and if it seems like it doesn't work, we'll switch to something else, is that we would look at the various areas that are set out in the information that we have, in the packet that we have, starting with the expulsion/due process procedures, and focus on those. and then move to areas of the hearing procedures and the stipulated agreements, unless people feel that it would be more time, that it'd be a better use of our time to just take all the comments at once.
Or let me pose another alternative. I don't want to extend this discussion out. Would it be more helpful for our administrators and members of the public to see, to hear board comments on these particular areas, and particularly with regard to what are the enumerated areas of potential consensus are, and then respond to that, no, you're going in the wrong direction, or yes, I agree with that, or whatever. I don't know if that would make it easier.
I'm seeing some heads nodding. So why don't we do that first then? We'll look at what areas we think I actually want to do that because I want us to look at specifically the areas that we have perceived consensus and see if in fact we do have consensus. So let's start with under the area of, well, I'm trying to think, expulsion hearing procedures, expulsion process procedures. Are there any board comments in those first two areas? We don't have any specific consensus, I don't think, identified in these areas, but are there comments that the board wanted to make in these two areas?
Mr. Gonzalez a question about that section.
Okay.
If it would be appropriate now.
Yes.
Under the second bullet, Mr. Gonzalez, though parents are advised by certified and regular mail of their rights before an administrative hearing panel, parents on occasion may not fully understand their rights to, then you got A, B, C, and D, right? And those include things like the right to be represented by counsel, to inspect and obtain copies of all documents to be used, confront and question all witnesses, and to question all evidence, which sounds a lot like what Mr. Bernard was talking about. And I guess my question is, what do you mean by their rights? Are those rights, is that a common sense usage of the word right? An ethical fairness usage or a legal usage?
It's actually, I believe, a combination of both, but in direct addressing your question, those are the rights written in the Ed Code.
Okay, so we're not doing the job that we ought to do, is what I read into that paragraph?
No, not at all. I believe that we do it. The issue is that some members of the public have commented to the board that a parent will read those and not fully understand it. And
Gotcha. I misunderstood who the agent in that was.
Right.
Are these, do they get that in writing, all that?
Yes, they do.
Okay.
However, I share with you that one of the discussions that you folks have had is maybe we ought to bold those documents so that they stand out.
Yeah, because, I mean, this sounds like a trial, about cross-examining witnesses and things like this, and I just don't, I go back to what I said earlier, I don't understand, I don't know what that means to a lot of our parents when they receive that. And even if you can read it and say, oh, I have a right to question witnesses, but what does that mean compared to what it would mean to someone with legal counsel?
Well, I think here's another factor that we've got to consider. My experience has been that, and I use the terms broadly, more educated, more middle class, more families who are resource-filled tend to have less difficulties with those portions of the letter. The opposite end of the spectrum, the poorer you are, when English is not your native language, though these documents are translated, they become more difficult to understand. I also will share with you that based on the conversations I have with parents, it's very clear to me that they're not altogether they're not altogether clear about when they read letters. And unfortunately, that's a common occurrence. Pick up any contract, and most of us are probably going to wade or not wade through it. And so, yes, I agree, it is a problem. Some of the language is technical in nature, and we've been battling for years now of translating technical language into a more understandable way. We tend to rely on Ed Code language to protect everyone's interests.
Ours especially, I presume.
I don't think there's any doubt about it. You are, as well as staff, obligated to follow Ed Code, yes.
Well, I think that's why we have the recommendation to continue to minimize the legalese, is precisely because parents get confused by it. And so I think one of the ways we have to discuss, the board has to discuss, along with staff, is how are we going to do that? What are we going to do to minimize that? Or at least to mitigate it in some way. I actually think we should have some sort of a cover letter that just says in very clear terms, your child, this is what's being recommended for your child. And then continue to have the legalese, or at least to the extent that we can't get rid of it, for students, for parents as full information, but some sort of very understandable cover letter that says in very plain terms what this means for the child. So, and that's...
May I just suggest for organization, I've got up the PowerPoint specifically on expulsion due process procedures that outlines some of the issues that have been brought up. The next slide talks about the recommendations, but I might suggest to the board that we wade through this and then move on to the next set.
That's fine.
And ask for public comment about it.
I'd love to hear if there are comments from our colleagues and the members of the public on these issues.
Our format again. Were we through making comments on this?
If we're going to this.
Okay.
I have some comments that I'd like to make, it looks like, so does
go
Mrs.
ahead.
Roy.
Okay. Okay, so let's hear from the board first, and then we'll invite additional comments.
Okay.
Ms. Harder?
Yeah, with regard to the legalese, the notification that parents receive, I have no problem with the documents being re-examined to highlight certain things, to make them more, noticeable. I have no problem with trying to craft a cover letter, although I'd be much more comfortable having Bruce Barsick or Michael Blatcher review such a cover letter. But I don't have any kind of problem with trying to convey critical information to parents in as clear a way as possible. With regard to the board having the supplemental hearing, which is number 3, that's where I have a great deal of difficulty, and I know that probably I'm diverging from what some board members would care to do, and I am not. I'm not in favor of holding the supplemental hearing except when necessary. I feel like the board has to balance a couple of interests: individual rights, those of students and families, versus school safety rules, upholding school safety for all students. And we do a balancing act when we have that supplemental hearing. And I think that often the balancing act falls in favor of the student and the family. In particular instances, there's a pattern that seems to have emerged from my perspective, and I could be wrong because I haven't documented it numerically or statistically in any way. But it seems to me that when a parent and a child come, or 2 parents and a child come to that supplemental hearing, and they express remorse and then say, but this is the outcome that we would like, whether it's not to attend El Puente or whatever, the board generally goes to a great deal of effort to try and fulfill those requests. And I think we end up with very inconsistent outcomes. A child who doesn't show up because they are working, or because their parent is not available, or because they don't have a parent to come with them, I think that child suffers. They may be just as remorseful, They may have extenuating circumstances that are equally as compelling, and yet we approve the administrative hearing panel. I'm sorry, I'm getting emotional because the expulsion hearings are very emotional. So I think we come up with very inconsistent outcomes from our supplemental hearings. We are trying to deal with punishing an individual, rehabilitating an individual, and yet create a deterrence for the entire group based on what happens with those individuals. And I don't think that we meet that obligation well in our supplemental hearings. I would like to have the administrative hearing panel be the one opportunity for a family with an opportunity to appeal to the board in the same way that Mr. Bursick walked us through when I asked him that question, so that the board would have the opportunity to hold a supplemental hearing of their own accord after reviewing a case that seems, not to have come up with an appropriate result. I really, really worry about this process because I think a bad decision by the board in those supplemental hearings, I think it subverts discipline at sites. I think it creates real problems at the site. And I have to be honest, I've had at least 2 instances where I've been able to receive firsthand feedback from when the board was, I would say, extremely gracious and merciful in one of those situations, and it produced a really unpleasant result. It doesn't always benefit the child or the family for the board to show a great deal of mercy. So I don't want to sound harsh. I just have real problems with what kind of outcomes that we as a board are producing in these supplemental hearings. So hopefully that provides some meat for people to respond to. In terms of, I'm getting ahead of myself. There were a couple of other things.
May I ask you a question, Mrs. Burdick?
Sure.
If a member of the administrative hearing panel were to attend the supplemental hearings and be able to speak, would that change your evaluation of that process?
I think it would make it a better process, but I think then we are dealing with a much more cumbersome process. Then I think we need to be prepared not to devote 10 minutes as specified in our board policy. We now allocate 20 minutes. I think that we're talking about a great deal more time, and that we would have to be prepared to have, several hours worth of closed session. And that's okay, in for a dime, in for a dollar, but I think that it would create a much more cumbersome process. And we would be, in a large measure, duplicating effort, particularly in terms of the administrators. And I think that when we talk about gathering administrators for the administrative hearing, we're drawing administrators off their campuses for 1 day a week. Obviously, we have Mr. Couch as the permanent member of the hearing panel, if you will. But then we would be asking administrators to come to closed session board meetings and commit time there as well. It's a balancing act, and
I just want to clarify also, I think, a question for you, Mrs. Harder, that you said that you think we often end up not making the same decisions for students who don't come to the hearing or whose parents don't come, that we do for the students whose parents do come. So I to some extent agree with you. To some extent, I'm not sure that I agree that that's entirely true, but I do agree that it's at least partially true. But I wanted to make sure that I understood what your recommendation would be then, and I think the recommendation would be to, therefore, really not hold the supplemental hearings.
not to hold it as a regular part of the process, that it would be the extraordinary part of the process, that when the board reviews what the results of the administrative hearing panels are, because only the board can sign off on an expulsion, that when we're reviewing it, if there's consensus that we wish to deal with a particular case, when we have that discussion in closed session, that we have the option of being able to hold a supplemental hearing. But it would be the occasional or more extraordinary circumstance than a regular part of the process.
And I have some concern about that too, because as you know, I've been concerned about, first of all, the overwhelming percentage of our expulsion cases are students of color who come from lower income backgrounds. But we also have students who are Anglo students who come from very privileged backgrounds. And often I think our process privileges them further. But I'm not sure that taking away that hearing would result in any loss of privilege to the already privileged and any additional fairness to the overwhelming number of students that we see from less privileged backgrounds. I think that hearing gives those families a chance to at least come before us and have us hear them. And I think in almost, and I maybe I'm not thinking all the way through, but it seems to me in the cases that I can call to mind quickly, that in almost all of the aspects of wherever we're trying to mete out punishment and, for lack of less pompous word, justice, that we do tend to take into account who shows up, who makes appeals, what kind of support people they bring with them, what kind of character witnesses they can provide, et cetera. That's not something that's unique to our hearing process. It seems to be sort of inherent in almost all hearing processes that those kinds of things do come into play. And I agree that they aren't always fair. The student who can't show up because they're working, who maybe don't have the parental support to be at the hearing, I agree. It's unfortunate that those students won't necessarily get the same benefit of the doubt that students who do come with their families get. But I'm not sure the answer is to stop giving the benefit of the doubt to the ones who come.
Yeah, but see, my additional problem with the second bite of the apple is that very often families who do come bring new information. That administrator had it in for my child, or this happened, or that happened, or
and that I think we
child
can monitor a
lied,
lot more closely than we have been, to make sure that we aren't getting new information, or that if we do get new information, that we do have someone from the hearing panel there.
So then if we do that, then I think in essence, we will be in many, many cases simply duplicating effort. Administrative hearing panel, supplemental hearing with a representative from the school site. I'm not sure how that helps the process, except in the more out of the ordinary case.
And that may be true. That's an issue. That's, I think, part of the discussion. Yes. Oh, I'm sorry. Can we just have?
Just put it in context.
Yes. Go ahead.
I just want to clarify something for the.
We do need to have you state your name into the record.
Tara Holland-Ford, Santa Barbara Teen Legal Clinic, and the Juvenile Justice Commission. The administrative panel can only take into consideration the facts of the incident. Okay, the board can take into consideration other facts with regard to what Mr. Gonzalez is saying. Maybe there's a drug problem. Maybe there's abuse in the family. Maybe there's other issues. That's where new information does come in. And that's what the board can take into consideration. But what's happening is, at the administrative panel, that information isn't coming forward. And that's not the fault of the panel, it's just not coming out. And maybe if the panel did get that information, they would be able to incorporate that within their recommendations.
I would actually disagree with that statement. I think the administrative hearing panel hears a lot of that, and I think that I don't know, I think that that the administrators on the sites in particular dig for that kind of information. They want to know the backstory. That's my impression anyway.
Okay.
And I just wanted to say that I think we get we get a lot of that information in the packets that come to us from the hearing panel. That's often how we become aware of it. So I think the hearing panel definitely does get a lot of that information.
Second, with regard to the findings, I don't know who actually writes the findings. I don't know if is it Mr. Gonzalez or if it's someone from the panel.
There are two, currently, as we speak, there are two district staff who write the findings. Mr. Bud Andrews, assigned on a part-time basis to the expulsion process, and myself.
Okay, so you're getting a packet from the administrators, which the students aren't reviewing. And I'm not saying that it's going to be skewed, I'm not saying, but the students don't review that. They do get those findings, but that's what's coming to you. So there may be information within that tape recording that you're not getting. So I do think that that's important. And I just wanted to go back to the legalese. You had mentioned writing a cover letter and having the attorney look at it. I do think it's not appropriate for the administrator's counsel to be doing that. Mr. Price, the board's counsel, should be looking into that.
I said review the letter, not.
Well,
Okay.
whoever, it
Okay.
should be the board's, because I think there's an inherent conflict with regard to Mr. Blatcher, who represents the administrators at the hearings.
May I just make one comment on that point? She is correct, which is why Michael is not here. What we're looking for is someone to advise the board. Mr. Blatchard could not do that. He advises the district, i.e. the schools. So it's a point well taken. Thank you.
Shall we move to additional comment, or do you?
Yeah, I just wanted to mention the last one on here, the lengthy process, which is that I'd like to see students go through this much quicker, because then they can be back in school. And I would love for the administrators to address that. I don't have any solutions. I don't know how to do that, and maybe they do.
Do we? Mr. Zettel?
Thank you. To contextualize this whole process a little bit, Dr. Malakoff, this is essentially a placement change for students, an educational placement change. This is not a catapulting of a student into the ocean, expelling. This is a placement change, and this is not a criminal proceeding. This is a hearing. It's not, even though some of these students have and will go through criminal proceedings, that's a whole different arena than an educational setting. And I really agree that we need to move the process forward quickly to get them to the next placement if that's what they need to have. And to listen to administrators, which you're about ready to do, is critical, because their say on whether or not their campus is going to be a safer place with the student placed in a more restrictive environment, albeit El Puente or wherever it might be, is critical to listen to. They're responsible for 2,000 kids sometimes on that campus. And so if you keep in mind that this is an educational placement change for a student who's done probably not a good thing according to Ed Code, who has been proven in the hearing panel to be a danger or a safety risk to the site or to themselves. And we are acting in loco parentis, maybe not so much anymore in legal terms. Now, Tara may disagree with me on that one, but that is an old legal term for school administrators. But shortening the process is critical. I really agree.
It seems like a long time between the incident and then them being back in school, and that's what concerns me.
Yes. I have to say, then, is putting someone in county jail just a placement decision?
That's a criminal proceeding.
Well,
We don't do that.
But this takes them out of the public schools of Santa Barbara, California, and puts them into a county, and we instruct them, do we not, that we don't put them in El Puente, they go to El Puente. All we are doing is kicking them out of the Santa Barbara School District. They're no longer our students. We tell them that all the time. It seems to me like that's more than a placement decision. That seems, and it's on the record. It affects. So if they go to another district, we have to inform the other district that they have been kicked out of our district. I just I'm quarreling with the language you use that seems to try to minimize the importance of this. It seems to me it's a very important decision.
Just a quick comment that doesn't have to do with these four pieces yet, but the comment that you made before this, Mr. Gonzalez, having to do with reexamining our discipline policies, because I think that that's very much in order, and I think we should be looking at appropriate protocols for between a first and second drug offense. Is the school site bringing all resources to bear? Youth services specialists being used, et cetera, et cetera. And then maybe make the switch to a third drug offense. I would welcome that discussion.
And also, just on the same topic, an issue of the time lag between the first offense and the second offense. Because if we have a first offense 4 years before the second offense, that's different than having two offenses occur in the same year or two.
I agree.
I wanted to also make a comment about that, because I think, with the numbers that we're talking about, I think we have to take a holistic approach to this. Right now, we're talking about the procedures based on the numbers of expulsions that we've been seeing over the last 3 or 4 years, which is pretty substantial and has been increasing, which might be diminished by changing the overall discipline program, and I was hoping that we would have, looks like we only have till 4 o'clock to complete this. We've got so many administrators here with, I know, a lot of good observations. I really want to hear from them. And, we started to go maybe to the consensus points, and to me, that would be an added consensus point that we would re-examine how, which offenses, when do we bring them forward? I have my own list of goals of things that I would like to see us do, and one of them is certainly for us to be providing more interventions if they're not currently adequate. And so I have a lot of questions about, do the kids get counseling sessions related to this? What are the different procedural steps? You listed all the steps, but I didn't see interventions there, and I didn't see the education piece, which seems to vary now. We hear different things that kids are doing. We used to call it home hospital, now it's individual instruction, and I think sometimes there's other approaches, and I'm not clear on what those all are. They seem to be somewhat different. So I'm just hoping that we can kind of get some feedback here on how things are being done at the site and what the administrators would like
Let me
to
ask,
see.
are you asking about interventions that precede all these steps?
Yes.
Or it could happen, could be interspersed in these steps. So I'm echoing what Ms. Harder said.
If I could suggest, I will refrain from making any more comments. I think it's very clear we need to hear from our school administrators that are here.
Yes.
Okay?
Okay, so we'll call them forward, and I'm just going to ask, because I think Ms. Rodriguez sort of identified some areas too that administrators may want to comment on as they're addressing us. I also have a significant concern that has been a concern in this district for a long time, and we haven't really spoken about it in a great deal in public, and that is the fact that the overwhelming majority of the students who come before us for expulsions are students of color. And is there something in our processes, is there something in our school climates, or is there anything we can do about the fact that, I'm not sure if we can do something about it. It's not the right issue. I think looking at why are the students of color disproportionately the students who are recommended for expulsion. So if anybody wants to attempt to tackle that in your comments as well, I would appreciate it. Thanks.
Ed Behrens.
I certainly think having interventions for students is important. I think we're all here to serve students and to serve students as best we can. You look at 100 expulsions as a lot. How many students do we have enrolled in the secondary district? I know at San Marcos we have over 2,200 students. So if you put these numbers into percentage, we're not talking about a huge percentage of the student population. Certainly we are concerned with the students who are being expelled, but in my experience, these are the students who have had repeated offenses and serious offenses that are affecting the safety of the schools. And so we're doing our job to protect the large school environment and to do our best to do that. Looking at some of the local districts prior to coming to this and looking at their policies, I think it's good to see what the other districts around us are doing and how we compare to them. Lompoc District has a zero tolerance on drugs. So any student on their first offense regarding drugs is automatically recommended for expulsion. For our district, we do, after the first offense, they have to go to the super program. They have to complete the super program. We also have the Fighting Back Against Drugs and Alcohol, YSSs at the schools. We have programs which we refer parents and students to through the YSSs, where they are able to have actually a class where they have a daily counseling with peers to try and rehabilitate students. So following that, then if they have a second offense for our district, they get recommended for expulsion. And these are the offenses that students are caught for. None of us are talking about all of the offenses that are occurring where students aren't caught for. Okay, I mean, there's a lot of things that happen at a comprehensive high school of over 2,000 students that aren't being caught. So we have to keep in mind that for every student that has 2 drug offenses where they're actually caught, how many times is that student coming to school high? How many times is that student possibly trying to subvert other students to do illicit activities at the school that isn't being caught? Is this a safety issue that we have to deal with? Yes, it is. Santa Maria District, 1 fight, 0 tolerance. Both individuals automatically recommended for expulsion. Our process is on a 3rd fight, a student is recommended for expulsion. Ventura District, 2 fights and 2 drug offenses. And Carpinteria, 2 fights and 2 drug offenses and 3 fights. So Carpinteria and us are the same. Ventura is stricter regarding the fighting than we are, and obviously Lompoc and Santa Maria are much more strict than we are. So I think hopefully that puts a little perspective on the topic that we're discussing. I don't think any administrator wants any student to be expelled. I think we're all working as hard as we can to have all the students at the schools be as successful as possible. And unfortunately, we do have students that make some poor decisions and have consequences. And that's my perspective. Yeah, next try.
By citing
Mr. Behrens, could you just state into the record your position?
Yes, I'm an assistant principal at San Marcos High School.
By citing those other statistics in places,
Is that right?
yeah. By citing the other places, are you saying that we're not strict enough, or do you think that we're okay?
I think that actually, I think our policies are pretty fair, and I think that we would do well to try and implement more interventions if possible in between the offenses. I think if you want to know my opinion on having more possibilities for students to do drugs and have fights at a school prior to having the consequence of expulsion, I think that that is not a good decision, in my opinion. And the reason why is because I think that we're setting a standard that we're saying this is not acceptable. And if you do these behaviors and get caught for these behaviors, that will not be tolerated at the school. And I think it sets a clear message for students. And in fact, at San Marcos, we do an all grade level assembly, and we go over all these rules with all the students at the beginning of the year to make sure that they understand this is what we're laying out as our expectations for you. And if you decide to make poor decisions, these will be the consequences that come to bear from your poor decisions. So I think it is fair, and I think that you do bring up a point about, certainly some people have issues that need to be remedied, and we're here to help those students too. So if we can provide more interventions, I'm all for that.
Ms. Cordero, yeah, this is not directed at you specifically, Mr. Behrens, or at San Marcos High School, but I mean, I find the figures from other districts really interesting. I suspect those were the same two districts that Mr. Gonzalez was talking about. It's interesting, but I really think that it should reflect the values of our district. And I guess my values say to me that I would like to be providing many more interventions for students, particularly with, fighting and drug offenses. And between the first and second drug offense, they're required to go to the super program. But I mean, I don't want to say so what, because I know it's a good program, but it's really a program that's not in our hands. It's another agency that runs the program. And I would like to see something very closely connected to us, something required with our youth services specialists, for instance.
Actually teach the program. The youth service specialists, they teach super.
Okay, well, very often I see them, they do it down here at night. And I'm just not sure that students and parents are making that really strong connection between what happens at school and, having to go to a program in the evening. And ditto for going, I think all three of the high schools and probably all four of the junior high schools, and La Cuesta as well, does the assembly at the start of the year with, the rules given. And yeah, that if I were, 16 years old, that might be really meaningful to me in the first couple days of school, but come April, if my friend's saying, let's leave campus and go smoke, I might not be remembering what somebody told me in August. You know what I'm saying? I mean, I think that we need to be providing constant interventions and be much more vigilant. And I really am open to that discussion about, third drug offense or, that kind of thing.
And that's your privilege to do that.
And I also just want to echo that as a teacher, I don't think necessarily giving large quantities of information in large numbers of students is really a way that we should even imagine that they understand it, because I think if I were a 16-year-old student, it wouldn't take until April for me to forget about all of that or lose interest. You're sitting there in the first week of school. I'm more interested, at 16, I'm more interested in, who's in my class and, what are they wearing today, and, whether I even pay attention to it while it's been given to me is a big
I mean,
question.
certainly that isn't the only way the information is given to the students. The students all receive the student handbook and discipline guide. The student and the parent have to sign a paper stating that they've read and they understand that discipline guide, which lists that in there. And then we're not talking about a student making a first offense here. We're talking about a student that has already had a first offense, has already met with the administrator. The administrator has met with the parent and also stated that if there is to be a second offense, that would be the consequence.
Yes, you're perfectly correct in that, so that is a good point.
I find it hard to believe that the students on our campuses don't know.
Exactly.
I mean, everybody knows that you aren't supposed to fight. Everybody knows you don't smoke pot in school. You don't drink booze.
And we do ask of students. We say, did you know that you weren't supposed to do this? And they say yes.
But I mean, I don't raise that point just so these don't hang out there. It seems to me that the salience of that message is what's missing. Not the message, and the salience.
Well, what the consequences are going to be too.
With the consequences.
Yeah.
And now we're back to where they're saying you have to have a consequence. It can't be ambiguous. It has to be absolutely clear and absolutely certain. That's deterrence theory.
Okay, I think we need to probably move on to with our speakers. So we'll go down the list and then we'll.
Well, I see Mrs. White. We don't have very many administrators, so if you come up.
Okay. Okay, come forward, but then I
Yeah.
want to make sure we do get to the people who submitted.
Because of the TV.
It's a very kind comment, but I think
Yes, and could you, again, because it's for the record, we need to have you state your name and your position.
Bonnie Switek, Assistant Principal at La Cuesta. I think one of the reasons that you don't have very many appeals where people come to the school board to argue with you about the consequences, they agreed. Many times I find that even on a simple suspension, parents thank me, thank us. They say to their kids, I told you so, I told you not to be doing this. And I think that, Dr. Noel, you're exactly right. These kids already knew. They know they're not supposed to fight and use drugs. And I think one of the reasons you're not getting a lot of appeals is because the parents are saying, I told you so, and they accept it and say, that's what happened. I've had parents absolutely thank me. I had it the other day. It wasn't an expulsion, it was a suspension. And the mother said, I'm glad you got caught at school, because I've been telling you. So.
Thank you.
Yeah.
Oh, see, all of you, our administrators here owe Mr. Barron's a debt of gratitude for getting the ball rolling.
Hi. Thank you. John Becchio, principal at Santa Barbara Junior High. I just wanted to make the comment that this is one of the most serious decisions that we make as principals at our schools. And so one of the comments I know from the public person that came previously was that parents aren't aware of the evidence that is going to be presented. And oftentimes, we meet with the parents of those that we're going to expel. It is often a lengthy meeting, and we present the evidence to them. I mean, they want to know, what is my kid being recommended for expulsion for? And so what we do is we lay that out. I additionally wanted to comment that this student is our student. They're on suspension, they're being recommended for expulsion, but what I tell the parents and the kid is, you are my student, you are my parent, and until this is settled and you move on to a different school or come back to us, you are our kid. And that means this whole process can be confusing. Please use me as a resource to maneuver through it. And I also refer to Michael Gonzalez. My suspicion is that happens at the other school sites as well. So, and then the last comment I wanted to make was I have some reservations about a third offense for drug use, and it's similar to what Mr. Behrens was stating, was that often the second offense isn't the second time the student has brought drugs to school. And I worry about the safety of the other kids that are there at that point. Thank you very much.
Okay, can we?
Any other administrators? Junior high? Did we get a junior? I'll do the rest of these.
Yes, let's do the public
Okay.
comment, and then we can bring
Okay,
up.
that's true. Cindy Cole. Sorry, you're.
I'm Cindy Cole. I'm a counselor at Dos Pueblos High School and co-chair for the district counselors. I wanted to say a couple of things. We as counselors are not involved in discipline. However, we are involved in the support of the students. One of the things that we as counselors get when they come, when there's an involuntary transfer, there's some anger, there's some upsetness on the part of the student, and oftentimes on the part of the parent. Each school site's a little different. Sometimes we are told as counselors what the student has been involved with, or we're just simply told this is an involuntary transfer. We don't know anything what's going on. That's a nice thing because we're not judging. But sometimes we're not even told that.
Excuse me, can I just interrupt you? You're talking about after an expulsion.
After an expulsion.
They're coming to your school because
That's right,
they're gone. It's not that without the expulsion, it's with
Yeah,
an
it's gone through the expulsion. So I want to tell you that I think that even though the parents and students are a little upset about the involuntary transfer, actually recidivism does seem to be very little. They see this as a second chance. They see it as a blank slate. I would just ask, though, that we, as counselors, we are confidential people. We do need to know a little bit more about what's going on, because when I call that student back into my office a couple times, 3 times, 4 times a year, either over grades or attendance or just an attaboy, attagirl, it really helps that they know that I know. And it's not as a means of checking up. It's more of a means of checking up to support. So I think the involuntary transfer is a very effective means of getting a student back on track, having an opportunity to start fresh, and go forward with that. Those students that come back to their same school, either after a short period of time or are allowed to come back, they again see this. Most times I see that they see this as a second chance. I think, though, more often they see it as a free ride. So I just want to encourage you to continue the process that I have seen. We counselors are happy that you have to do the dirty work, but we want to support the rehabilitation. So as I said, sometimes I'm not even sure who is there. So when I'm selecting classes for them, I need to be very careful about how I select, what classes are the last period of the day, what classes are the first period of the day. Should I put them in YSS classes? Would theater be an active way for them to act out some of their behavioral issues? So it's really good for us as counselors to know. We certainly keep that private, but we need to know that more. So, did you have a question?
No.
Okay.
No, quick comment, though. Just good feedback for administrators. The involuntary transfer portion of an expulsion, so students expelled when they return from wherever they've been, usually El Puente, that part of the expulsion proceeding is probably the part that produces the most tears for a student, when they're advised that it's highly unlikely that they would be able to return to their home campus. Probably produces the biggest emotional impact on a student. And
on their family.
And that's something that, well, particularly, well, I won't.
Don't even
No, I won't go there. But I do think that that's something that needs to be spelled out better in the paperwork in terms of the consequences of an expulsion, is that it's usually accompanied with a transfer back to somewhere other than the home high school. And I guess on that note, I'd also like to share with administrators that it's really, really difficult for the board when we get an expulsion recommendation where a principal says, yeah, you know, it might be okay for the student return to the home campus. That's really hard for me as a board member to deal with, because I don't know whether the principal felt like they were under tremendous amount of pressure during the administrative hearing. I'm never sure what the circumstances are that are connected with that.
I'd like to address that just a little bit. I think there's always that feeling that you want a second chance to help that student also, that maybe they could have done more. I do want to reiterate, though, that there is that anger. And by the way, there's when they are involuntary transferred, some of the teachers feel put upon. Why should they take on another school's problem? It's not fair. And yet, I just have to say that my experience has been that the students and parents eventually do respond positively, and they become part of that school. And it's definitely a fresh slate.
I mean, we try to remind parents that we're all parents. And as a parent, I think I'd rather have the clean slate for my child.
And remember, you, as the students are at another campus, even though they know quite a few kids in Santa Barbara, they're not subject to that same group coming up and continuing to badger. So I just want to give that. And administrators, I do want to invite you to utilize your counselors.
Thank you.
Thank you, Mrs. Cole.
You raise a question.
There's a little
Excuse
bit
me.
of
I'm
confusion
sorry.
here about the terminology.
Okay, I just wanted to finish. You raised an issue that has been a concern for me, and I think it's a little bit of a I don't want to say controversy, because I think I may be the only one who's really conflicted about it, and that is the issue of not going back to your home high school. I certainly understand the thinking behind that, and for the most part, I completely support it. But there are times, I think, when for students to have that as a possibility, when the student, especially if the student is being transferred at maybe 10th grade, where they could do their 11th grade at another school and then possibly come back to graduate from their home high school, as a possibility and as a goal, that there can be some benefit to that too. So I understand both sides. It's one of those issues that I think is tough to resolve, because with each student it's probably different. You can't say it's going to work for every student, or that it would be the right thing for every student. But I also don't think that it's necessarily the wrong thing for every student. So I'm glad you brought that up. Dr. Noel?
Well, my understanding is that there's a very clear distinction between an involuntary transfer and an expulsion. And I associate the term involuntary transfer with something that goes on short of expulsion. That's true. Okay. And that, of course, involves making a decision about where. But when we expel, I think this is one of the places where we have the lowest tolerances. I'll pick a number. 90% of the time, we do not include in our decision return to the campus of origin.
I think it's probably more than 90. I think it's
Maybe
probably
more,
like
okay,
98%.
Yeah, and that I say to you administrators is because we understand what the implications of that for you. For the student, then what's happening is, say, you're leaving this district. You're not, and for whatever period, whether it's a semester or a year, you're at El Puente or at some other site, you are not in the Santa Barbara district. You may reapply to this district, at which time you may reapply, but you will not be considered for one of in the high schools. You'll be considered for 2 schools, not 3. And for the junior highs, you'll be considered at 3 schools, not 4. So it's I don't mean to parse this too finely, but there is an important distinction there, I think.
Yes. I mean, I think that an involuntary transfer, and I was going to raise that issue, but I think we can deal with that at another time. But I think an involuntary transfer may be one of the things we want to be looking at as some intervention steps as well.
Any other counselors before I go on? Do you want to speak?
Fran Wagenick from La Colina Junior High School and counselor. I wanted to go and just speak on the counseling perspective on the second offense for drug and alcohol use. Certainly as counselors, and we want, our focus is, as yours is, that all students are safe and feel safe at school. So in respect to weapons and fighting, I feel that we're on the right track. But I also agree that the second offense is the proper time for a student to be expelled from the district, for not just the reasons that were shared here, but that from a counseling perspective, it's time for that student to hit bottom, as they say in the recovery world. Those of us who are familiar with recovery understand that for most people who struggle with addiction later on in life, they begin using at a very early age. The average age is around 11 or 12. So if we're looking at 13, 14, 15, a student who doesn't get it the first time that they are suspended for drug or alcohol use, if they're continuing to use after they've been through super, when they know that people are watching them, there's a good indication that that student needs, they need the 2x4 upside the head to get it. And I say that in a truly caring, loving manner.
In a purely figurative sense.
But I feel that they need some interventions, and what we have in the city of Santa Barbara and in the entire Santa Barbara community is a wealth of resources, and like we have Sobriety High for those who, that the county education office runs. So it's almost like we're helping families move out of that place of denial and really see what the ramifications are. So that was my thought in regards to what's been shared so far.
Thank you.
Questions, comments, protests? Thank you. Okay, thank you.
Thank you very much.
John Greer.
Mr. Greer, you had additional comments that you wanted to make?
Yeah, I mean,
Okay.
I don't know how you're going to proceed. I guess that's my first question.
Well, we're
I'm
running short on.
assuming that you're not going to-
Yeah, I don't think we're going to get through everything that we had anticipated. So why don't you go ahead and make the additional comments that you wanted to make at this point?
John Greer. To go back on point, which was the expulsion due process procedures that we were discussing, I think you need to go back to the root, which is what's causing the people to be coming back before the Board of Education instead of the issues being resolved at the administrative hearing panel level. And I think that if you ask that question, then and start reviewing it, you might resolve many of the issues that get to your level, because it seems to me that if there's an overabundance of people coming out of the administrative hearing panel saying they didn't feel they were treated equitably for whatever reason, and that they want the Board of Education to hear their plea, then it seems to me we ought to be addressing what's going on at that level that's resulting from that. And I think that in my letter of October 10th, I made a suggestion that you put something in bold print that said, attention, this hearing may result in the expulsion of your son or daughter from school. You and your child are entitled to have legal representation at this hearing. But I think, when it's one thing to get a document that says, the student, it's a whole other thing when it's your son or daughter. Pay attention, folks. Your son or daughter, if they go through this, may be expelled from school. And I thought it was great that your Liebert and Cassidy counsel indicated that you could even go further and say, there are resources in the community that you can talk to, because I think we've talked around it here, but I think it's very clear that if a family has the financial wherewithal or the educational background, then they're certainly going to represent and be represented and understand their rights. But in many cases where people, for whatever reasons, don't have the financial resources or the educational background, they're not going to understand their rights. And in situations like that, it's easy to feel, what do I need to do to resolve this issue? And I think there's been many steps, and Mr. Gonzalez and I have talked about it, that have been improvements in those areas. But I think that's one of the things that I would encourage the board to focus on in their policy, is that make sure that the administrative hearing panel it is resolving and discussing those issues if that's where you want to go, and so that you would have less of them coming here. And obviously I have comments on other areas, but I'm assuming that we're going to stay on point.
We're going to certainly try to, but I just wanted to concur with a lot of what you said, and in fact we have talked about adding the bold language that you mentioned previously to our documents, but I do want to disagree with your comment that we have parents coming to our hearing, to a board hearing, because the issue hasn't been resolved at the hearing panel. I think parents and students come to the board because they perceive it as one more chance to not have to have the consequences that the hearing panel recommended. And it's not because the hearing panel didn't do their job, it's because the parent or the student doesn't like the outcome. And that's why they come to us. So I'm not sure that if we continue the process, if we were to continue the process in the same way that we have it, I'm not sure that we could really expect or anticipate any change in that, because parents would always feel that if they didn't like the outcome at the hearing panel, that they could come to the board and take their shot at getting a different outcome.
Well, I would respectfully disagree on the issues that I've had come to me. The reason that the expulsion didn't stand up was because rules, procedures, whatever, were not followed. And in fact, there is a procedure that you can appeal to the county schools. And the times I've called Mr. Rosso, whether it's this school district or Lompoc or wherever, inevitably the cases that I've been involved in, the schools have backed down because they've not followed the procedures or the policies that they were supposed to follow. So I don't wish to engage in an argument here, but I think that I really believe that my comments were directed more towards, spending more time on identifying those issues related to making sure that parents understand, that students understand the severity of going to an administrative hearing. Because it's not something that's casual, as Dr. Noel said. I mean, if you're getting expelled from the school district, you're not coming back here. I mean, I don't know what the percentage is, but you're not coming back here. You're going to go to a county school system, the L20s or whatever. You're
Well,
not coming
the majority of
back to
them
school.
do return to our district after they serve their expulsion.
Okay.
Mr. Greer, actually, I would also disagree that they come to us for procedural reasons. I don't think most parents most parents who come to the expulsion process would have that kind of knowledge to attack it on a procedural basis. I think they come for very emotional reasons, and I think it's to take a second bite at the apple. But I even if that's the case, I guess I would want to share with the public that we have had over the past year one case appealed to the county, and that appeal was rejected. So I don't want to leave the public with the perception that we're bumbling along, creating lots of procedural errors at the administrative hearing and then at the board hearing, because that simply is not true. It may be true in other districts, but not
I never
here.
made that statement. That's your statement.
Okay.
What I said was there are other reasons that people come
Well,
other than just a second bite at the apple.
And I do appreciate where you're coming from, but I think your mission is different from mine, and yours is to advocate for the individual's rights, for the family and for the student. And I think from a board perspective, we have to do that unwieldy balance of trying to do what's best for the individual and what's best for all the students in all of our schools.
To that we can agree on.
Thank you, Mr. Greer.
Can I ask a quick question before
Yes.
we proceed? Will we have a chance to ask administrators additional questions since it's almost 4 o'clock?
It certainly would not be, I would not oppose extending our time a little bit to ask those questions. I don't know how the rest of the board feels about that.
How many more public speaking forums do we have?
3.
Three. So I think once we get through those 3, then we can,
I'm specifically interested in hearing from principals. I have a couple of questions.
okay. And if the principals don't mind staying, then we can ask them when we're done with these. Yeah, and it's probably difficult for you to tell the board that you do mind staying, so we probably have you here.
Ms. Renard, do you want to go a second time?
First of all, I wanted to say it's really a shame that there's no parents here. Kate Smith is the only parent in attendance at this board, so far as I can tell, and I hope at the next meeting that you hold it at a time when parents can attend, so that I think it's really important that you get the information straight from the parents. There was some things I heard that were sort of concerning. One is the attorney that was the district's attorney that was here earlier said that he said that schools sometimes make concessions as part of offering a stipulated agreement, and that, I really don't think that if that's the case, then that the board should know about it, because now if the school is going to start bargaining with students and families about, if they take a stipulated agreement, they're going to get this favorable treatment, that's exactly the kind of intimidation that causes stipulated agreements to have a bad name. Schools should not be making concessions. Either the student gets their bite at the apple fair and square, or they don't. or they have the hearing process. But if the school is going to be wheeling and dealing with students, that's not an arm's length negotiation, and I think the board should know about it and make sure that that's not the case if you go with stipulated agreements. The other thing is, I was concerned about the fact that when these students are transferred back, and the term was used as an involuntary transfer, that the school they're being transferred to apparently isn't given the information about them, and that's not a good situation. I'm surprised. It sounds like it usually works out well, but I'm surprised that it does under those circumstances. The other thing is, Mr. Becchio said that at Santa Barbara High, anyway, the students that he's been involved with that are being expelled, he has a long meeting with them, and the parents are given the information. But unless he can say that all families have a long meeting where everything is explained at the school, then maybe the students that he has an involvement with are, and that's great. But unless they all are, then it's not necessarily that's not necessarily saying that the problem's taken care of, because it's only apparent, taken care of for some families. Also, Mr. Zettel's comment that it's just a placement change, it's not a criminal proceeding. Well, I think that's a little understatement. At El Puente, where they're being transferred to, it's my understanding that they have to go through a pat-down every time that they enter the school. They have to empty their pockets, and they're under constant video surveillance all the time. So it's like a little prison in a lot of ways. So it is very much like being criminalized. And they're also in a school, I think, with a lot of students who are on probation. So it is not just a placement change, Mr. Zettel. The other thing is the comments that, well, when students are being expelled, that they're really a big problem, they've committed some act that's dangerous. And, that also gives a false impression of the concerns that are being expressed here, because the students that, and I want to thank Mrs. Cordero for continuing to be concerned about the students that don't have a lot of resources and money, and are limited English speaking, because it's not those students that get the raw end of the deal for the most part, and the students that are, I think that the Teen Legal Clinic is concerned with, and the students that I'm concerned with are the students where it's not just a clear-cut case of, well, a student has a major antisocial problem and they've committed an act that's dangerous. It's those situations where a student may have gotten into a situation and there's reasons why that need to be looked at. Maybe they haven't received the support they should have, or this or that, but it's those kind of expulsions that we're really here talking about. It's not, so to characterize it as, well, definitely, what's the problem? These students have committed an act that should, they can't stay at school and all that. That's not really the issue here. It's more the gray areas, and those are the students that need to be protected by really fair and well thought out expulsion processes, and also processes that lead up to processes that catch students before, in between the first offense and the second offense. If nothing's done, there's going to be a second offense. So, as rules as far as, whether you expel on the first or second offense, well, almost what's important is what's done in between the first and second offense, because there's going to be a second offense if nothing is done, most likely. The other thing is, the last time I mentioned about school-wide behavior programs as being shown to be the real preventions behind a lot of expulsions, and so far I haven't heard that brought up. I hope that's part of the discussion when this meeting continues. And it's a little frustrating because I've followed this process for about a year now, and originally the school board wanted to cut down on the time they're spending with expulsions, and it seemed like a logical way to do that was to the reason these expulsions are coming to the board now is because that's what your process is, except for, you know, the students where the families don't show up for the board hearing. But there was some discussion of just making it so that only families who wanted to come before the board for whatever concern they had about the administrative hearing process, then those students could be the ones that come before the board, and that would cut down significantly on the number of expulsion hearings the board was having to hear in a fair way, it would seem like, but that wasn't an option presented to you by Mr. Gonzalez when the options were presented to the board, and I still don't hear you guys discussing that option. It seems like a fairly balanced way to be able to resolve the board's main concern. I'm not quite sure why that's not on the table now. Thank you.
Thank you, Ms. Renard. And just for the record, Mr. Becchio is at Santa Barbara Junior High. Mr. Gonzalez, did you want to speak to that last point, or?
I think it's very clear from the board in a number of conversations before you that option has been considered.
Thank you, Mr. Gonzalez. Our next speaker?
Tara Hecklin, Ford.
I'll be 2 minutes or less, I promise. Tara Holland Ford. I just have two quick comments. One is with regard to Ms. Harder's suggestion about the supplemental hearing and having a student or their parents request that hearing, and then the board decides whether or not they'll actually hear it. One thing to think about is what criteria will you be using to base that on, because it could become pretty cumbersome with regard to how you actually can make that decision. And it should have, if you are going to go that way, there should be some type of criteria that either the family or the student or the attorney could rely on when making that request. Second,
Excuse me, can I just interrupt you?
Sure.
Can I ask you, I thought your suggestion was that we would look at the papers and the board would
has
decide.
to review every expulsion.
Correct.
And it's the board making the decision about which ones that they would want to review, not the parent requesting, although that is another option that is still in front of the boards, which Ms. Renard was just talking
okay,
about.
I misunderstood you then.
Yeah,
I thought you were stating
Yeah.
that the parent. I would encourage you to allow the parents to request a hearing, and if it does cut down on it to put criteria with regard to what the board is looking for, then I would encourage that also. But I do think the supplemental hearing is an important part of the process for those who do come before it, and I would hope that, you know, I think one of the administrator stated that some students decide that was it. We messed up and we don't want to go forward. And I do think that's true. And we do have some clients with the clinic who bring us the administrative panel findings, and we tell them it is what it is. There's nothing you can do from here. And so they decide they're not going to go to that appeal. Finally, it's just with the stipulated agreements. The one issue I see with the stipulated agreements is it's not just waiving your due process rights and waiving the administrative panel hearing, but if you have someone who knows the system, knows what maybe certain offenses are worth, you have someone who can sit down with the administrator, with Mr. Gonzalez or Mr. Blatcher, as we've done in the past, and come up with a agreement that works for both sides, both for rehabilitation purposes and for returning back to the school at a certain time. So I do think it's appropriate to have an outside person assist those people with those stipulated agreements. Thank you.
Thank you, Ms. Holland Ford. Okay, our next speaker?
Kate Smith.
I'd like to publicly thank John Greer and Tara for being here, because they're working without any kind of remuneration. They are the advocates for our students. So what I'd like to do right now is try and find a way that we can pull the money that you give to El Puente automatically. Did you know that? $35,000 to $55,000 a year. You just give it to the county. You didn't know that? You do.
We have in years past when they've had financial difficulties, and it doesn't happen automatically, and it did not happen this year.
Mary Stark said it did. So anyway, I'd like to have that money go to the Teen Legal Clinic and or to the Understanding Juvenile Justice Program, so that there can be some advocacy. What we've been trying to tell you is there is no advocacy. There's no public defense for these students or these families. And you can talk all you want about stipulated agreements. I would say 98% of the families that are coming before you wouldn't know what a stipulated agreement was, wouldn't know that they have a right to an assessment. I would go with the stipulated agreement if you could then say that it's mandatory that they have an assessment for educational learning disabilities and or mental or emotional issues. That's what's causing the behavior in the Mental Health Services Act wraparound. That's the first thing they say. All bad behavior comes from something. This is what John Greer was trying to have you get to. It comes from needs unmet. Please find a way to advocate for the kids, to pay for that. Joan Esposito doesn't get paid for her advocacy. It would be very simple if we just balanced out this equation so that the families did get a fair shake, that the students did get their needs met, and that way you wouldn't have all these people coming back saying, well, I didn't know, I didn't understand, please, let us have another bite of the apple. Tom Sneddon said to Joan Esposito that these kids get a bigger bite of the apple than they deserve. And in defense of the children, I think they should get the whole apple. Thank you very much.
Thank you, Ms. Smith. Okay, that concludes our public comment. So, Ms. Rodriguez, did you want to specifically ask questions of the principals who are still here?
Well, one of the principals I was going to address the question to has left, but what I was interested in hearing, because we've heard a lot from counselors and assistant principal, one junior high principal, which is great. And what I'm interested in from Mr. Morgan, because you more sort of recently were a principal in another district, I was interested in, from your standpoint of having seen how they did it, Temple City, is that right? And then Mr. Swanitz has expressed to me in conversations some ideas about the way things were done in his previous district. So if you could maybe talk a little bit about, briefly about how you think we do things differently and that suggestions for improvement.
Thank you for the opportunity. I support Board Member Harder with the process she's described in both districts that I've spent my entire career in. The process for the expulsion was exactly what she described.
Again, Mr. Morgan, I'm sorry. Can we have you just state your position?
I'm Craig Morgan, the lucky principal of San Marcos High School, home of the Royals. I apologize. The two previous districts, El Monte Union High School District and the Temple City School District, both expulsionary processes were exactly as Ms. Harder has described. It cut down significantly on the length of time the student was out of instructional programs. So that would be my total support in those districts for that process she's described. So that would be it. The other thing I'd like to ask is, as you modify different processes and steps for 48,900 expulsionary processes, that I hope that we would be given the opportunity to be engaged in that conversation with you.
Thank you very much. Mr. Turnbull, I don't want to leave you out.
Certainly.
Do you have anything that you'd like to add?
Or Miss Abney.
Or Miss Abney, I'm sorry. I'm sorry. I was thinking in terms of larger high schools, but I would like to hear from you too, of course.
As far as
come to the microphone and introduce yourself, please.
Paul Turnbull, principal, Santa Barbara High School, not the Royals. As far as my experience with other school districts and interventions concerned, I don't have any for you at the high school level. Reading through the ed code that changes ever so often, there are two things that pop up as far as interventions are concerned. One we currently use at Santa Barbara High, which is under the 48,900 code, U, and there is no delineation of pages here for you. I'm sorry about that. To read it to you, a superintendent or principal may use his or her discretion to provide alternatives to suspension or expulsion, including but not limited to counseling and anger management program for a pupil subject to discipline under this section. 48,900 being the overall section. We currently do that, and my site level interpretation of that is a minimum 1 half-day parent visit to campus. I've explained this to you as a junior high principal and again as a high school principal. And there are definite merits to it. There are limitations to it as well. But for the most part, when we see parents walking through the classrooms, there's certainly the social internal accountability that comes from having mom or dad come to your class with you. And from the parental aspect, it involves parents more so in the school than we would ordinarily see with students who are either at risk or have issues. The second thing that popped out to me, I won't read the entire thing, but it is Ed Code 48900.6. As part of or instead of disciplinary action prescribed by this article, the principal of a school, the principal's designee or superintendent of schools, or the governing board may require a pupil to perform community service on school grounds or, with written permission from the parent or guardian of the pupil, off school grounds during the pupil's non-school hours. You know, lots and lots of creative ideas come to mind with this particular Ed Code. And when you're talking about, again, interventions, there are a variety of different things, campus beautification, etc., that come to mind. They could be as invasive or non-invasive or counseling oriented as we see fit, or as individually appropriate as we could possibly prescribe. There are a variety of things currently happening on school campuses that are individual, and I would take this opportunity to ask the board and the district office to work very closely together to help the sites come to some sort of agreement on what those interventions would be. Currently, you have a system wherein schools act in individual manners because there are only 24 hours in the day and we're all running pretty quickly. If we do this in an overt fashion for the purpose of intervention, then I think you could get good things out of this one Ed Code.
I appreciate that, and that's along the lines of the conversation I had with Mr. Swanitz about some of his experiences in a prior district, and I think it's a great suggestion to work. I mean, I'm assuming you guys talk to each other pretty frequently as it is now, but to be able to collaborate on coming up with some alternative models for intervention that you might all be using sounds very promising to me.
I have a quick question.
Yes.
So these are cases where they might otherwise have been expelled? I mean, is it before they're about to be expelled, or?
I read this personally as suspension. The last one, 48900.6, included the word expulsion. But I think that there are very few individual cases wherein in lieu of expulsion would apply. For the most part, I think that suspension is the best way to go, because that's where I think our intent is the education of a student in whatever situation it may be.
So it's most appropriate with a student who you might see as being expelled in the future, who's moving down that path and a way to intervene, rather
Correct.
than
There
someone
are,
who's.
if I use I'll stay away from the example of drugs and alcohol. There are multiple off-campus interventions that I'm not qualified to deal with. But if, for example, we have a student who is having an issue with theft, theft is something that we can delve a little bit deeper, perhaps, and if it's something to do with home life, if the student is using this as a way of acting out and drawing negative attention, we can use a variety of interventions to get to the root of that and avoid just simply remedying things with punishment, right?
And I just wanted to say that 48900.6 actually says that we can't do this in lieu of expulsion if the student is going to be expelled, unless it's part of the rehabilitation or some stipulated agreement that we have. But as part of a suspension, in order, sort of as almost an intervention, I think that's something that we probably could do more of district-wide.
Yes,
Yeah.
You're right. That was at the very end.
Yeah.
I'm a slow reader. I didn't get that far.
That's because you didn't graduate from Santa Barbara High School.
That's right. I wasn't allowed to return to that school.
Okay, so other questions from?
No, thank you.
Okay, you're off the hot
Thank you.
seat. Thank you. Ms. Abney, did you want to? Okay.
I'm sorry, I didn't mean to slight you.
Oh, that's quite all right. Kathy Abney, principal of La Cuesta. And I think I'd just like to speak to some of the intervention pieces that might happen between one event and another. And we use extensive YSS resources, teen court resources, parent project resources, counseling services on campus to try to kind of head off the next offense. The one thing I would say, if you're talking about doing something about the changing, maybe going to 3 drug offenses, the one thing I've always been kind of concerned about is if the first offense is in 7th grade and the second offense is in 11th grade, and we still say it's the second offense, and we automatically expel, I think we probably should have something in place that says how far apart did those things happen. Now, the kid that offended last spring in May and offends again now in September, absolutely, I think that should be an automatic recommendation for expulsion. But the 7th grader and the 11th grader, what happened in between there, 7th grade might have been the one experimentation before, this time, and I think that I almost would be advocating for making that 11th grade the first offense. So I think there's some point for discussion for how far apart were those offenses, because we've always said the secondary career, it's the second time in a secondary career. I do need to tell you, though, that every colleague I've ever worked with is always very clear with a student and a family after the first offense that if there is a second offense under the influence or in possession of drugs, paraphernalia, alcohol, there will be a recommendation for expulsion. It's the automatic process in our district. And we're, if it's a Spanish-speaking family, we have an interpreter there. I mean, I feel confident to tell you that my colleagues are, really, true to that process. And I know it's a daunting process, but I also feel like from the school standpoint, we're as upfront with it as we can be. And I agree with Mr. Becchio. If I'm involved in that process, I am available to parents as a resource if they need me. And we always encourage them to call us, because it is, I don't like sitting at that table and having to represent the school. It's a nerve-wracking process for me, so it has to be a nerve-wracking process for the family. So that's...
I wanted to ask you a quick question. I'm sorry, Mr. Becchio, did you want to?
I just want to follow up on that eventually.
Okay. Mr. Gonzalez mentioned a school district in which a number of the expulsion cases, or what would normally be an expulsion case for drug offenses, are instead sort of reassigned to the continuation high school in that district. How would you feel about a situation like that?
I would argue the way we are situated right now that would be a travesty. Because right now I have 2 teachers teaching on a campus in classrooms with very little administrative support, very little counseling support. Those particular continuation high schools are located in a situation where they have full-time administrative support and full-time counseling support. If in fact those students are not dangerous behavior problems, and if we had a situation where we had full-time administrative support and full-time counseling support, I don't think it's an inappropriate placement. But right now I've got teachers in classrooms trying to teach, and when kids act out or kids come in under the influence, they have to stop teaching to deal with the situation, to call one of us, to call a parent, to chase them across the street when they leave campus. So right now it's not an ideal situation, but in a situation where we have full counseling and administrative services, then I wouldn't argue that was an inappropriate placement. And I think it would depend on the student, and I think it would depend on their behaviors in addition to the drug piece. If they were fighters and and huge discipline problems, it might not be appropriate. But certainly, I have great YSSs, and I think the drug intervention piece and some of the counseling pieces we could very appropriately deal with counseling services and that type of thing.
Thank you. That was a helpful response. Thank you. Mr. Becchio?
Thank you.
Thank you, Ms. Abney.
Thank you. When we're talking about the third offense for drugs, Ms. Abney makes a great point, and that is the time issue. And all of us principals, when we go before the panel, have to answer the question about are there any other means of correction? And I think that when someone has offended in 7th grade and someone has then again their second offense in 10th, we have to still answer that question. Is there any other means of correction? I think probably in that case, there could be a good case made for the fact that there are other interventions we should try before expulsion. So I wanted to comment on that because I made the point that 2 offenses, I worry about extending it past that. However, there are exceptions with respect to time in our district. That's it.
Thank you. Thank you, because we've wrestled with that recently. Okay, well, we didn't get through the entire discussion as I think we optimistically thought we might. And I'm sure that we will have this discussion continued probably over a period of a few meetings, if it's anything like today. And it should be, because I think this is an important discussion. It's important for us to be able to have a thorough back and forth about it. And I don't think it's a discussion that we want to try to squeeze into a limited time period. It's too important. It affects the lives of our students and the lives of their families. And I do think that that for me at least, I joke, well, I don't joke. Other people joke about the fact that I'm, a Dawn. But for many of our families who are longtime residents in Santa Barbara, the schools that the students attend are really significant to them. And it's not just a matter of casually switching from one to another or leaving one school. When you're a 3rd or 4th generation graduate from a particular school, it has strong meaning for the families. And transferring those students isn't really the same thing as transferring a student who just moved to Santa Barbara because of the impact that it has. So I think these are discussions that are really important, have the potential to profoundly impact students as well as their families. And I'm glad that we were able to give it this much time, and I hope that we can find a significant amount of time to continue the discussion. So thank you all for being here. I know we kind of put you on the spot and didn't let you leave, but I appreciate your giving up your time and the comments that you all made, and also from the members of the public who took the time to come and give us your feedback on this issue. We appreciate that as well. So I think we will now, if there are no further comments on this, we will adjourn into closed session. Our next regularly scheduled board meeting will be on December 12th. Thank you.